Just wait for them to fix it, that cat. The crowd attention, like that. They don't include you, but they trade it because we can fix it later on. One record before civil information for only. So still going to be should be full attention to allow some. The person that door, the next time we get there on the pocket, the other all rides. He deals with that. And I'm going to get into the same, these are all businesses. I'm going to hear one that's going to the all comfortable. Yes. That's why I came to this. Oh, it was. It's not, it's a hard. Something that only can bother me. You and then you're become all alone. I can get a doorbell. All right. Everyone, please be seated. Thank you. Good morning, everybody. This is the 2 o'clock calendar. It is July 16, 2026. The court orders for taking of DNA and fingerprints that were given on the first calendar this month shall apply to all matters on this calendar. When I call you up, I'm going to give you your release conditions. I'm not going to say out loud all of them. They'll be on your paperwork. At a minimum, we'll say no drugs without a valid prescription and don't drive without a valid driver's license. If I do set a security appearance bond, you can go to a bondsman. It's my understanding they collect calls. The names and numbers of bonding companies are in some walls of the jail. If you need help finding it or getting any assistance, please ask one of the officers for help. Now, since this is being streamed, I do read the victim's rights advisement. If a person is a victim of a crime with a case pending before this court, they are advised they have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present in court proceedings, to choose whether or not to be interviewed by a defendant or a defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who's been convicted of causing their loss. If they've already not been provided with a written statement of all victims' rights, you should contact the Victim Services Division of the Prosecutor's Office. Okay. Okay, we're gonna, person who's got the American Sign Language interpreter. Here's it. Could you tell maybe to get closer to the screen? Okay, can you see, make sure she can see it, okay. Okay, first of all, will you sign language interpreter identify herself for the record, please?
Good morning, Your Honor. Jennifer Morse from the Court Interpreter's Office.
Great, thank you. Good morning. All right, ma'am, I want you to give me your name and your date of birth, please.
Yes, my name is Senia Canales, and my birthday is March 9th, 1983.
Okay. You have a child support arrest warrant.
I've been paying all along. I have all the paperwork.
Well, all I can say is I showed there's a warrant for $304 that you'd have to pay to get out of custody.
Okay, and so okay, let me think. How do I pay it if I'm in jail? How do I pay it, and where do I show the evidence that I've been paying child support?
Oh, so she can pay that through the bonding up to how can she pay it, by the way? Do you know how she can pay the child support arrest? She's got a $300 and $4 per cash one.
She has to go down to bonds and fines to pay it?
No, she has to pay cash.
She has to go down to bonds and fines and pay it?
She can pay it here
At bonds and fines before that?
at bonds and fines. Yes, you can pay it at bonds and fines.
I do have a credit card. I have it on my phone. Can I use my phone when I'm there in the jail? I don't
Apparently
have it with
not.
me. I don't have it with me.
Apparently not.
How do I pay?
She will have to have somebody go down to bonds and fines and pay it with cash.
Okay, so then, as a deaf person, I do have some deaf friends. How do I contact a deaf friend from in the jail to tell them to go?
Okay, what can you speak? Can you
We have a phone device you can use.
Do you have a video phone? They don't use the TTYs people don't use TTYs anymore. So do you have a video phone I can use?
We'll have to have classification help her get in contact. We'll have to have our classification help them.
Your next court date will be at 201 West Jefferson on July 23rd at 10 o'clock in the morning.
Okay. Okay. Sure. No problem.
So you
I'll
would
bring
have
all
to-
my paperwork showing that I've paid.
Okay.
Is that all? Thank you, Your Honor. Have a good night.
Okay, sounds good? Okay. Javier, Alvaracin, Albarracin. Okay, sir, your name and date of birth, please.
Javier Verasin, 5/18/1994.
Okay, get two matters before me. One is 2026 114933. That one you have a bench warrant on possession of narcotic drugs, drug paraphernalia, and then also criminal trespass in third degree. You already have a lawyer in that one. Your court date will be at 175 West Madison Street for a status conference on July 22nd at 8:30 and a witness preliminary hearing on 2 days later on July 24th at 8:30. Can return to the scene of the alleged crime. We're having any contact with alleged complainant or victim. All right, and bond was set by your judge, the amount of $250. Now, on the new case, which is 2026 127422, you're charged with possession of dangerous drugs. However, based on the limited information I have right now, I don't find probable cause. Doesn't mean you won't be charged with it. Criminal trespass in the first degree and possession of drug paraphernalia of class 6 felonies. On those two charges, you do find probable cause. Now, on the case that you have the bench warrant for, I saw you had your initial appearance on April 22nd, 2026. So, and by the way, I did appoint an attorney for you, and your status conference will be July 22nd at 8:30 and witness preliminary hearing on 7/24, 8:30 at 175 West Madison Street. But since I've had probable cause in these two felonies, pursuant to Article 2, Section 22 of the, Article 7.2 of B, and Article 2, Section 22 of the Arizona Constitution. At this time, you'll be held without bond, but you'll have an extra evidentiary hearing on July 23rd at 1:30 at the same address. And that's, your lawyer will explain to you what that means. That's to determine whether bond can be set. All right, step to your left, please. Joshua Chap. Okay, so your name and date of birth, please.
Joshua Joseph Chap, 12/28/1984.
You also have two matters for me. First one is it's a bench warrant in 2025 134001 on a possession of narcotic drugs, class 4 felony. You already have an attorney. You'll have your court date at 175 West Madison Street. Okay. We're fine. Okay. July 22nd at 8:30. And your judge set bond in amount of $10,000 secured appearance bond on that. Now, in your new case, it's 2026 127433. 3, charged with possession of narcotic drugs and resisting arrest. Let me just double check one thing here. Oh, yeah. Knowing that you're out on the bench warrant, you had been initialed on about April 22nd of this year. I do find probable cause in regards to these felonies. So pursuant to section 7, rule 7.2B, article 2, section. Lower the radio. You lower the radio just a little bit. Okay. Pursuant to rule 7.2B and article 2, section 22 of the Arizona Constitution, you'll be held without bond. And your court dates, you have appointed a lawyer for you. It'll be July 22nd and July 24th for status conference and witness preliminary hearing at 8:30 175 West Madison Street. And you'll have an evidentiary hearing at same address on July 23rd at 1:30 to determine whether bond can be set. Your lawyer will explain that to you. Okay? But this time for the time being, you'll be held without bond. Josiah Mahapi. All right, so your name and date of birth, please.
Josiah Mahapi, 06/18/1998.
Okay, so you're charged with murder in the second degree, class 1 misdemeanor. I am appointing a lawyer for you. Your court dates will be at 175 West Madison Street at 8:30.
The county attorney's only one person.
Oh, I didn't know she was appearing on it. Okay. For these, will the state announce their appearance, please?
Yes, Your Honor. Good morning. Ashley Stetson on behalf of the state.
Okay, thank you. I didn't know you were appearing. Okay, sir. Anyway, sir, I told your court dates would be July 22nd at 8:30 for a status conference at 175 West Madison Street. At this time, there's a preliminary hearing scheduled for July 24th. Your lawyer will explain to you what might happen and why you may or may not, that may or not occur. Just for preliminaries, obviously, you can't possess any weapons and no alcohol in regard to this. Now, I do have a recommendation from the state. If you would like to, Ms. Destin, would like to be heard on that?
Yes, Your Honor. The state outlined its recommendation in the written recommendation that the state submitted to the court. Your Honor, the state is asking for bond to be set in the amount of $1,750,000 cash only. That is based on the suspect's criminal history as well as the allegations in this case. Additionally, Your Honor, the state did know in its recommendation that the suspect in his prior case, his probation, he was ordered to submit to domestic violence treatment or anger management treatment, as well as substance abuse treatment, Your Honor. As Your Honor is aware, based on the allegations, the suspect did appear to be extremely intoxicated at the time of the murder. So the state does believe that that bond is appropriate. Thank you, Your Honor.
Yes, okay. Sir, one thing that I had noticed is that one of your priors is for discharging a firearm in a municipality. I'm not going to do a bond as high as the state's recommended, but I'm also adding something else. Your bond is going to be $1 million cash, but if you were able to post your bond, you'll have to have an ankle bracelet with a curfew. You'd only be able to leave your home during hours approved by pretrial services. You'll meet with your attorney. Your attorney can always attempt in your assigned court to see if that bond can be changed. All right? Step to your left, please. Ms. Stetson, do you have any other matters you're appearing on?
No, Your Honor, that's it. Can the state be excused?
Yeah, one question on the other matter that got moved to 5 o'clock. You can be able to proceed by that at 5?
Yes, Your Honor. The state received information. I'll be forwarding to the court shortly.
That's what I want to know. Okay, very good. Thank you.
Thank you.
Have a good night. Your shoe. Bye. Colton Campbell. All right, so your name and date of birth, please.
Colton Campbell, 6/5/99.
All right, so you have two matters. One's probation violation, and the other one is a new case. Let's deal with the probation violation. CR 2023-133978002. You're on probation And you're alleged to violate terms 3 and 5. And just get in front of that. I did appoint a lawyer. Your court dates will be at 201 West Jefferson, which is the Central Court Building, July 22nd at 8:30 for revocation arraignment hearing. Now this applies. I have to edit this, by the way. Okay. This applies to both. If you get out, contact your probation officer within 72 hours for release. No weapons, no alcohol, and no drugs without a valid prescription. Anyway, your judge, a judge in the probation violation court said bond for you in amount $250 security appearance bond. Now you have your new case 2026-127419. Actually, I have to change it again. You're on intensive probation, by the way. So you have to contact if you get out, contact your probation officer within 24 hours of release. Okay, I had to change it to 24. Did you get it? All right, let me just sign it again. Okay, very good. Okay, so this one, your charges of burglary in the second degree, aggravated assault, unlawful imprisonment, threatening, intimidating, and assault. I'm appointing a lawyer for you, and the other one was at the East Court Building, 201 West Jefferson. This will be at the same time your status conference on July 22nd at 8:30. So I'm appointing a lawyer for you on both. Tell your lawyers about it because they only may transport you for one if you're in custody. This will be at 175 West Madison Street. Status conference on July 22nd, 8:30, and a witness plum hearing scheduled for July 24th. I already told you your other release conditions. Bond will be a security appearance bond of $20,000. Step to your left, please. Anthony Michaels. Okay, sir. Your name and date of birth, please.
Anthony Michaels, May 27th, 1990.
Okay, sir. You are charged with 3 counts of aggravated assault, 2 counts of endangerment, it's a class 3 and a class 6, 1 count of disorderly conduct, class 6, and 2 counts of criminal damage, class 1. I am appointing a lawyer for you. Could you hear me, or we're just saying? Could you hear me? Yeah. Okay. When you said I thought you couldn't hear me. Okay. Your court dates will be at 175 West Mass Street. Status conference on July 22nd. Witness preliminary hearing July 24th. Both scheduled for 8:30 in the morning. All right. You're not to have any contact with the alleged victim. No weapons. And bond for you is set in the amount of $25,000. Security appearance fund. Step to your left, please. Keith L. Thomas. Your name and date of birth, please.
Keitha Thomas, July 15th, 2005.
Okay, you are charged with armed robbery, class 2 felony. I'm appointing a lawyer for you. Your court dates will be at 175 West Madison, both at 8:30. Status conference on July 22nd, and a witness plum hearing at this point scheduled for July 24th. You're not to return to the scene of the alleged crime. You're not to initiate contact with the alleged victim or victims or any complainant or witness. No weapons, all right? The state was asking for a $75,000 bond. I'm setting it at $15,000 security appearance bond. If you're able to post it, you better show up or else you lose your bond and a warrant will issue for your arrest. Okay, step to your left, please. Michael Goldsboro. And so your name and date of birth, please.
8/12/1992, Michael Goldsboro.
I guess you're on probation for armed robbery. And I put a lawyer for you. Your alleged violated terms 6 and 7, and your revocation arraignment hearing will be at 201 West Jefferson on July 22nd at 8:30. Obviously, if you get out, contact your probation officer in 72 hours. No weapons, no consumption or possession of alcohol, and no drugs without a valid prescription. And your bond is set in the amount of, was set by a judge down there in probation violation court in the amount of $5,000, but it's a security appearance bond.
Say that again?
$5,000 security appearance bond.
Okay.
But I said, if you get out, contact your probation officer within 72 hours of release.
Okay.
Okay?
Thank
Step to your left, please. Brandon Green. Right, so your name and date of birth, please.
Brandon Michael Green, 11/21/1984.
All right, sir, you were charged with possession of dangerous drugs, class 4 felony, possession of drug paraphernalia, class 6 felony. I'm appointing a lawyer for you. Don't lose your paperwork. Your court dates are at 175 West Madison Street at 8:30. Status conference on July 30th. Witness preliminary hearing on August 3rd. All right. You're going to have drug testing and monitoring. I'm releasing you to pretrial services. You got to report to them within 72 hours and make sure you get your drug testing. You'll get an envelope from one of the officers explaining to you how you contact them, because if you don't do it, there'll be a warrant for your arrest. All right? But it'll be about 4 or 6 hours before you get out. Okay, step to your left, please. Maurice Freeman. And sir, your name and date of birth, please.
Maurice Freeman, January 19th, 1957.
Okay, sir. You have two, give me 1 second here. 2 charges, both 2 bench warrants. Is he waiting for a court appearance tomorrow morning in Phoenix?
Yes.
Yeah, what's going to happen tomorrow morning? 10 o'clock, I think it is. You'll be seeing a Phoenix judge in regard to that one. You have a warrant out of Florence also. I don't know if they're going to put something on you. Okay, so I just want to mention to you about that. But anyway, you're in 2026, your judge said bonds in these amounts. In 2026, 118982 bond was set in the amount of $50, and in 2026, 110385 bond was set in the amount of $500. So your total bond on that $550 as security appearance bond. I don't know what Phoenix is going to do. Okay. All right. So step to your left, please. And if I didn't tell you the court dates, by the way, sir. And I did appoint, you already have an attorney. It'll be July 22nd, July 24th at 8:30 at 175 West Madison Street. And that'll be in your paperwork. Okay. Step to your left, please. Casey Green.
Good morning, Your Honor.
Your name and date of birth, please.
Casey Joseph Green, May 14th of 1992.
I do want to check one thing first. Okay. Okay, so you're charged with criminal trespass in 2nd degree and criminal damage, class 3, misdemeanor. Give me 1 second here. And I do have a victim impact statement here. A lawyer will be appointed for you at your next court date. And actually, I have to amend that, by the way. Your arraignment hearing will be at the Santan Justice Court. The address will be in your paperwork, July 21st at 8:30 in the morning. You're not to return to the scene of the alleged crime or have any contact with the alleged victim or victims. Bond is set in the amount of $500 security appearance bond. Step to your left, please. Diego Amador. All right, sir, your name and date of birth, please.
Good morning.
Take off your hat, though.
Oh, good morning.
Your name and date of birth. You with us?
Who was that?
Your name and date of birth.
Oh, okay. Diego Amador, February 29, 1992.
Okay, you got 3 matters before me. Let's deal with first 2020-101-782. Got a bench warrant at a Superior Court based on a probation violation. You already have an attorney. Your next court date will be at 201 West Jefferson for a non-witness violation hearing on July 22nd at 8:30. If you get out, contact your probation officer. This applies to all 3 of your matters. If you get out, contact your probation officer within 72 hours. No weapons, no alcohol, and no drugs without a valid prescription. And your judge said bond the amount of $500 security appearance bond. Now in CR 2019-002844, same court date. Everything's the same release conditions except for that one. Your judge said bond amount of $300 security appearance bond. Finally, you have a new case, criminal trespass in the first degree, class 6 felony. I'm appointing a lawyer for you. Now, let me just double check something here. Anyway, those are 201 West Jefferson. And new cases also be a status conference on the same time, July 22nd at 8:30, and a preliminary hearing set for July 24th at 8:30. If you're in custody, they're not going to take you to the same place at the same time. So make sure your lawyer knows about the other case. Okay, so you'll initially have 2 lawyers, and I'll be in 2 different courthouses. They'll probably be merged into one. All right, you can't return to the scene of alleged crime.
What's the bond for that one?
What?
What's the bond for that one?
I haven't got the other ones.
Okay.
I told you where. I'll get back to you in a second.
All right.
Don't return to the scene of alleged crime. No contact with the alleged complainant or witnesses. No alcohol, no weapons, and contact your probation officer. Bond in this one is the amount of $100. So your total bonds on those are
900.
is
Yeah, because it was.
1 second. I'm looking at this.
Does it have put
On the
that?
new case, by the way, your bond is $100.
Yeah.
2 probation violations. So it's 6. Total bond is $900 security appearance bond.
Yeah, because I was actually in detox why they put that.
That's
in.
something you have to talk with. You mention over with your lawyer.
Yeah.
Discussion. These what the judge down in probation violation court
Okay.
ordered. Okay.
So it's $900, right? For
Luis Sanders Romero. Good morning, sir. Your name and date of birth, please.
Luis Sanders Romero, 6/19/1997.
Okay. Oh, it looks like you're at IPS. I'm gonna have to amend all 3 just for reflecting. Okay. You got 3 matters before me. 2 of them are probation violations. First one, and all 3 of them, obviously, you get out, contact your probation officer within 24 hours of release. I'll be changing it because you're on IPS.
Yes, sir.
No alcohol and no weapons, no drugs without a valid prescription.
Yes, sir.
Let's see, you're on probation for possession of dangerous drugs on both, and you're alleged to violate on both 3, 4, 5. 3, 4, 3, 4, 5, and 15, by the way. Your court date for those will be July 22nd at 8:30. I told you about no weapons, contact your probation officer within 24 hours, or at least so. And I appoint a lawyer for you.
All right.
Second. Okay, the other probation violation is 2023-130526. It's going to appoint a lawyer for you, same conditions, with the exceptions that you have to contact your probation officer within 24 hours. I'm making that change.
Yes, sir.
Now let's get to the new matter, 2025-000892002. Something on the petition it mentioned you've been arrested for these charges, criminal trespass and unlawful means, but it's an arrest warrant, so you didn't actually appear on this one. But I did appoint a lawyer for you. I don't know if you heard me speaking to one of the other gentlemen, is that the other ones are at 201 West Jefferson. These new charges are at 175 West Madison. Ultimately, they'll be combined in the same court, and I did appoint a lawyer for you. So the status conference is July 22nd at 8:30, same time as your revocation. The other matter, and July 24th at 8:30 for witness for hearing. So talk to your lawyer about that so they know about the other matter. I told you about the release conditions. And because bond was set on the 2 probation matters, I did set bond of $100 on that one, which lesser than the bond was suggested on that. All right, so step your luck, please.
Can you sign number 20?
When?
Can you sign number 20?
20? I didn't sign it? No. Okay, good. All right. You must be needing an elder. Name and date of birth, please.
K-A-A-Q.
Without yawning, talk to me. Give me your name.
Nina Marie Elder, 1092.
10/8/92?
Yeah.
Okay. You're here on a probation violation. And let's see here. Looks like you're on probation possession drug paraphernalia alleged to violate terms 3 and 5. And I appoint a lawyer for you. Your court dates will be July 22nd at 8:30 for revocation arraignment hearing at 201 West Jefferson. You get out, contact your probation officer within 72 hours. Same thing, no weapons, no alcohol, no drugs without a prescription. And your judge in that court set bond for you in the amount of $150 secured appearance bond. All right, step your left, please. Kathy Borsia. Kathy Borsia. You have to take off hat also. All right, your name and date of birth, please. Your name and okay, okay.
Hello,
So it's okay.
I'm a cochlear implant person, not yet though.
Okay. Your name and date of birth. Can you hear me?
I can hear you. Go ahead.
Is that okay now? Can you hear me?
Well, I might, let me, now talk.
No, wear them. If you can't hear me at all, wear the headphones.
I can hear you.
You sure?
Kind of.
What part? All right. At any time you can't hear what I'm saying, you let me know, okay?
Well, I've never used this, so. Go ahead. I'm not gonna say much, but.
I have to make sure you hear and understand everything.
How long has it been?
No. Is there any way we can adjust it?
I'm so sorry.
No, sorry. Officer, is there any way we can adjust this? She can't hear me.
I do, but not.
Much better?
Well, he's getting it. It's like not. Okay, go ahead. Say something. Okay.
Can you hear me now?
Well, I mean, I can hear you. But
But do you understand the words I am saying?
what?
Do you understand what he's telling you?
Yeah,
All right. What is your date of birth?
10/5/54.
What is your name?
My what?
Name.
Kathy Borchard.
Okay. You are charged with aggravated assault. And the level of the felony is wrong here, but I'll leave it up to the prosecutor's office to decide what the level would be. I am appointing a lawyer for you. Your court dates will be at 175 West Madison Street for a status conference on July 30th at 8:30, and a witness preliminary hearing scheduled 2 days later on July 24th at 8:30 in the morning on August 3rd. All right, it'll be in your paperwork.
Okay,
Now, the prosecutors wanted you held on a $75,000 bond, but I decided, based on all the circumstances, I'm going to release you to pretrial services. You must report to them within 72 hours. You read what's in that envelope. You must contact them. And before you're released, they're going to have an ankle monitor put on you. And you can't remove that. And that you'll be only can leave home during the hours approved by pretrial services. You cannot initiate contact with the alleged victim. You can't possess any weapons. Do you understand everything I've said?
I'm sorry. I know, Your Honor, I'm so sorry.
All right, don't.
It's frustrating. It's frustrating for me too. I'm embarrassed.
Don't be embarrassed.
I can't help it.
Officer, just tell him everything I just said to you will be in your paperwork.
So everything's in here.
Okay, everything's there.
Okay, thank you. Let's do it that way.
Are we ready to go now? Okay.
Yeah. Just tell him she'll be out in about 4 to 6 hours. Okay.
Thank you for having patience.
Okay.
Thank you.
Okay. Llewellyn Lewis.
Llewellyn Albert Lewis III, June 21st, 1977.
You got a warrant at East Mesa Justice Court and failure to stop on police command, class 2 misdemeanor. Rather than spending people on cases like this, I would say to people, is it worth the time you spend in jail here?
No, Your Honor.
So show up for court at the East Mesa Justice Court. The address will be in your paperwork, August 5 at 9 o'clock in the morning. They ask that you don't be released OR because it's the third warrant. And each day you can serve your sentence in piecemeal. Doing jail time you ordinarily may not serve. You know what I mean? So just show up. Okay, I'm going to release you on overcognizance. You'll be out in 4 to 6 hours. Be there on August 5 and be smart.
Thank you, Your Honor. Can I say something?
Yeah.
The last judge I saw, I tried to go in and make a payment on this and they wouldn't accept my money, so she said she dropped the...
Well, that's between you and the JP. I have no control over that. I was saying, you better be there.
Yes, sir.
You know what I mean? Okay.
I will be there. Thank you.
David McDowell.
Mr. Honor.
Okay, hold on a second. Officers, everything okay? Do you want me to keep going?
Keep going.
Okay. All right, your name and date of birth, please.
David McDowell, 6/22/70.
Well, your hair looks a whole lot different in that picture than it does here.
Thanks a lot.
No, it just, you've got a new case at a Goodyear City Court. The address will be in your paperwork. It's on criminal damage, okay? You cannot return to the scene of alleged crime. You cannot initiate contact with alleged complainant or witness. You understand that? And be there on August 5 at 1 o'clock. Don't be late. But I'm releasing you on your own recognizance. You'll be getting out in about 4 to 6 hours once I process you. All right? Step your left.
Thank you, Your Honor.
Okay. Esbaldo Sanchez Leon.
Yes, sir.
Okay, your name and date of birth, please.
Osvaldo Eric Sanchez Leon, September 29th, 1996.
All right, sir, you're charged with possession of drug paraphernalia, class 6 felony, appointing a lawyer for you. Your court dates will be the status conference on July 30th at 8:30 and a witness preliminary hearing on August 3rd at 175 West Madison. I'm releasing you on own recognizance. Make sure, show up for court and see if they filed charges against you or not, but it's your responsibility to show up for court, all right?
Hmm.
You'll be out in 4 to 6 hours.
Thank you.
Oh, I want, okay, that's it.
Done,
Yeah,
Judge?
he's done, yeah. Augustine Medina Diaz.
Yeah, one.
Oh, that's right. With a memento por favor. Okay, will the interpreter please identify his or herself for the record, please?
Hello, this is Lucia, interpreter ID 2528.
All right. Good morning. All right. Sir, could you tell us your name and your date of birth?
Señor, ¿nos puede dar su nombre y fecha de nacimiento?
Agustín Medina Díaz, 22 de junio del 76.
Augustine Medina Diaz, June 22nd, 1976.
Sir, is Spanish your primary language?
El español es su idioma principal, ¿correcto?
Correcto.
All right.
Right.
Do you need the assistance of a Spanish interpreter to make sure you understand everything that occurs in your case?
¿Necesita la asistencia de un intérprete de español para comprender todo lo que ocurre en su caso?
Así es.
That's right.
Okay. So I'm appointing the office of the court interpreter. They will provide a Spanish interpreter for you during your case.
Vamos a apuntar un intérprete en español durante su caso.
Bien.
Sir, you are charged with possession of a
Yes.
weapon by a prohibited person, a class 4 felony.
Señor, usted tiene cargos por posesión de un arma por una persona no habilitada, un tipo de delito clase 4.
I am appointing a lawyer for you.
Le vamos a apuntar un defensor.
Your court dates are at 175 West Madison Street in Phoenix.
La corte será en el 175 West Madison Street de Phoenix.
The hearings are at 8:30 in the morning.
La audiencia será a las 8:30 de la mañana.
You will have a status conference on July 30th.
El día 30 de julio va a tener una conferencia estatal.
And a witness preliminary hearing on August 3rd at 8:30.
Y una audiencia preliminar el día 3 de agosto a las 8:30.
You cannot possess any weapons at all.
No puede poseer armas.
Okay.
Okay.
I've decided to release you to the supervision of the Pretrial Services Agency.
Decidí liberarlo con la supervisión de una agencia de servicios prejurídicos.
You must report to them within 72 hours of your release, which will be in about 4 to 6 hours.
Debe reportarse dentro de las 72 horas de su liberación, el cual va a ser dentro de las 4 a 6 horas.
Okay. You'll be getting an envelope from one of the officers, which should also be in Spanish.
Va a recibir un sobre de los oficiales que también va a estar en español.
And it'll tell you how to contact pretrial services. If you don't contact them, a warrant could issue for your arrest.
Ahí va a informarle cómo contactarse con los servicios prejurídicos. Si no los contactas, se va a liberar una orden de arresto.
Sir, do you have any questions for the court?
¿Tiene alguna pregunta para la corte?
Solo tener la dirección del día de corte.
I would like to have the address for me to go the court date.
Okay, the address for your courthouse is 175 West Madison Street in Phoenix. It will be in your paperwork also that you'll be given.
La dirección es la 175 West Madison Street de Phoenix. Eso lo va a tener en los papeles que le van a dar.
Okay. Anything else, sir, you want to ask?
¿Algo más, señor? ¿Algo más que nos quiera preguntar?
No.
Okay, very
Está
good.
bien.
Thank you. Get your line. The
No.
interpreter, thank you very much.
Thank you for
Okay.
calling Lion Bridge. Interpreter
Yeah, thank you.
2528 disconnecting. Have a nice
Thanks. Right now, we should have the two FOJ matters. Let's just take Joseph Cuevas first. Good morning, sir. Your name and date of birth, please.
Joseph Daniel Cuevas, 1285.
Okay, the reason the two of you are last, because we do fugitive justice cases last.
Okay.
It takes a little bit longer. I don't want either one of you to think you're being discriminated against just because it takes longer, okay? You, however, sir, have two matters before me, okay? One is a warrant out of the Salome Justice Court, which is in a different county. I'm not even sure which county it's in, on a driving license suspended. Right now, it looks like your arraignment hearing is scheduled for July 21st at 8:30 at that court. The address is on your paperwork. They may have to pick you up. I don't know if that's the court date will stay, but that's what it is right now. All right. Because you have the FOJ warrant, I did set bond so you can get credit for both and they could take you there. So I set bond for that in the amount of $250, just so you can get credit, okay? It's a different county, so I don't have much control over it. It was $250, okay?
Good.
Now, the big thing, however, is your fugitive justice matter. And let me just try and check something on my notes. Oh, it's from the state of Oregon. A warrant for your arrest was issued by the state of Oregon. They want you back on this warrant. Now, did you read that paperwork on that laminated card before you came to court?
Yeah.
Okay. Did you understand it?
Yeah.
Okay. All right. You have a choice to make at this time. You can choose to either give up your right to an extradition hearing and be sent back to the requesting state within 30 days with some modification. And I'll explain to that in a second. Or you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states before you'd be sent back to the state of Oregon. Now, here's what I want to explain to you. Yours is a little bit affected by that other case. If you choose to waive your right to an extradition hearing, you'll be held non-bondable in Maricopa County for a period of up to 30 days to allow time for Oregon to come get you. That 30 days would start tomorrow, as long as you don't have any criminal charges anywhere in the state of Arizona. But since you have the state of Arizona charges, the 30-day period would not start until those charges are resolved, okay? If you decided to have an extradition hearing, I would set your hearing set a date for you at 201 West Jefferson to meet with another judge on July 27th at 1:30 in the afternoon. Now, I cannot appoint a lawyer for you to represent you because extradition matters are civil in nature, but you have right to hire a lawyer at your own expense if you want to. Now, you would not be entitled to bond because it's a parole matter and they've requested that you be held without bond. Okay. A governor's warrant signed by the governors of both Oregon and Arizona is required to extradite you to Oregon. That can take up to 90 days. Do you wish to waive your extradition or keep your rights and have an extradition hearing here in Arizona?
So if I waive my rights, they have 30 days to give me?
Once that other charges are taken care of.
Yeah, I'll do that.
You want to do that?
Yeah.
Okay. So now I have a whole bunch of questions to ask you, okay? I understand at this time you do want to sign the waiver of extradition. I have to ask you some questions as I'm making a record of this proceeding. Now, did you read the waiver of extradition paperwork?
Yeah.
Do you understand you do not have to sign this paperwork? Do you understand you don't have to sign it?
Yeah.
Okay. Do you understand that you have the right to an extradition hearing?
Yeah.
Okay. Do you understand you have a right to hire a lawyer at your own expense?
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you're returned?
Yes.
Do you understand you have the right? No, you do not have the right to bond, okay? But it's still the 30 days are affected by the local charges, okay?
Right.
You want to give up those rights and sign the paperwork?
Yes.
Has anyone threatened you or forced you or promised you anything to get you to sign the paperwork?
No.
Have you used any drugs, alcohol, or any medicine in the last 24 hours that might affect your ability to understand these proceedings?
No.
Okay. I find you have knowingly, intelligently, and voluntarily are signing the waiver. I'm also signing it. I'm directing the sheriff's office to notify Oregon that they're ready to you're ready to return. The requesting state will have 30 days from tomorrow to pick you up unless there are local charges pending, which there are. If there are local charges pending, the 30 days will not begin until the conclusion of that case. Once again, I don't know if they take you there on the 21st or not. I'm not sure how that's going to work.
Okay.
All right, let me just. They don't use the pad anymore, right?
That,
They don't use the pad anymore?
no, he's going to in a minute.
Oh, yes.
Are you done signing?
Yeah. I thought you changed it, not using the pad anymore. Okay, so why don't you step over there, please?
Oh, it's right there in front of him.
That's what I
You
meant.
can sign it on the pad.
They're not coming up here anymore.
No,
That's fine.
yeah, go ahead and sign on the pad, please.
I knew it changed. They couldn't remember. Wow.
And then sign one more time, please. Okay, thank you. I'll print out your paperwork.
Okay.
Good.
Yeah, you could. All right. Your name and date of birth, please.
Jennifer Ursula Carrillo, 8/19/88.
I'd like everyone to know why the delay. So you heard what I said, the reason? Okay. All right. So let's start over again. You see your Jennifer Correa?
Mm-hmm.
That's yes, right? Yes?
Yes.
And you're born on 1988?
Yes.
Okay. All right. Just double check something. So I'm not doing everything by memory. Okay, it looks like you fugitive justice case, and I'm trying to remember where that's from. Hold on one second. For a minute I said Fayette. I'm saying it was Arkansas, but it's no, it's Fayette County.
Payette County, out of Idaho.
What? Iowa, right? That's
Idaho.
Iowa?
Idaho.
Idaho. And normally I write these things down. That's why. Okay. Actually, I think they want you to held without bond, but I'm not gonna do that, but, yeah, they did, but not gonna be an issue for me, okay? But anyway, you read that laminated form?
What was that?
Did you read that laminated form about it?
Yes,
Do you
I did.
understand it?
Yes.
All right, sure. And, so a warrant for your arrest was issued by the state of Idaho. The state wants you back on this warrant. And as I stated, you have, you have a choice to make at this time. You can choose to waive up your right to an extradition hearing and be sent back to the requesting state within 30 days, or you can demand an extradition hearing and that governor's warrant be signed by the governors of both states before you send back to Idaho. If you decide to waive your right to an extradition hearing, you'd be held without bond here in Maricopa County Jail for a period of up to 30 days to allow Idaho to pick you up. That 30 days would start. Is it working?
Yeah, go ahead.
Sure. Okay. Now, do you wish to waive extradition or keep your rights and have an extradition hearing in Arizona?
I'm gonna waive them.
You can waive them? Okay. As I to add the other gentleman, I have to, just ask you these questions. I understand you do want to sign the waiver of extradition. I need to ask you some questions as I'm making a record of the proceedings. Did you read the waiver of extradition paperwork?
It is, please.
Okay, I'm going Mary right now. Do you understand you don't have to sign the paperwork?
Yes.
Do you understand you have the right to have an extradition hearing?
Yes.
Do you understand you have the right to hire a lawyer at your own expense?
Yes.
Do you understand you have the right to demand that a governor's warrant be signed by the governors of both states before you're returned?
Yes.
Do you understand you have the right to bond?
Yes.
Like I've described, unless you have local charges? And do you understand you have the right to give up those rights and sign the paperwork?
Yes.
Does anyone force you, threaten you, or promise you in any way to get you to sign the paperwork?
No.
Have you used any drugs, alcohol, or even any medicine in the last 24 hours that might affect your ability to understand the proceedings?
No.
All right, I find that you are knowingly, intelligently, and voluntarily are signing the waiver. I'm also signing it. I'm directing the sheriff's office to notify Idaho that you're ready to return. The requesting state will have 30 days from tomorrow to pick you up unless a local charge is pending. There are local charges pending. 30 days will not start until the conclusion of the day. Okay, in a second, she'll tell you when to sign the pad.
All right.
And good luck with.
I have reviewed the sign sheet while you're.
Oh, that's just, sorry.
Okay, go ahead and sign, please. So try signing slower and a little bigger, so it'll take. So can you do it less squiggly?
Okay.
Or just not- Okay, and then one more time, just like that.
Yeah.
And that one's getting one more time. Okay, I'll turn off your paperwork, thank you. Thank you.
She got involved.
Okay. Now we have the, which is two house calls. Vicente Sanchez in isolation because of bizarre behavior, charged with resisting arrest and theft. Appoint a lawyer for him. The court dates will be at 175 West Mass Street for status conference, July 30th at 8:30. Witness public hearing on August 3rd, 8:30. Will be released to pretrial service. He must report within 72 hours. Of release, he can't return to the alleged crime or have any contact with the alleged victims or victim. Actually, we have three house calls. We also have Nora Dane DeLema, charged with 2 counts of burglary in 3rd degree, 2 counts of theft of a credit card, 2 counts of theft, 1 count of fraudulent use of a credit card. Appointing a lawyer for him. His court dates will be at 175 West Mass Street, July 22nd, 8:30. Status witness preliminary hearing on July 24th at 8:30. He cannot return to scene of alleged crime or initiate contact with alleged victim or victims. Bond is set in the amount of security appearance bond of $2,000. And we Vale Lloyd. Oh, by the way, Nora Dane was, he was safe cell because he was not following orders. On Vale Lloyd, he's an NASW, suicide watch. So, charged with burglary in 2nd degree, burglary, possession tools, criminal trespass in 3rd degree. A lawyer was appointed for him. His court dates will be at 175 West Mass Street, July 22nd. Witness public hearing July 24th at 8:30. He can't return to the scene of alleged crime, have any contact with alleged victims. Bond is set in the amount of $1,000. Security appearance bond. Okay, we are in recess.
All right.
Everyone, please be seated. You got called in, right? You got called in? I heard Mel was. Welcome. It's a light calendar after the rest of the night was heavier.
Oh.
So it's good. And the English sign, American Sign Language person earlier.
Okay. You didn't worry about the age. You're.
I'll be right back. Unless you want, can you get it to my desk with my paperwork?
What do you need?
In the middle of the chamber, all the paperwork I have, calendar. Okay, thanks so much. All right. Good morning, everybody. This is the 5 o'clock calendar, July 16th, 2026. The court orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. When I call you, I'm going to tell you your release conditions, at least part of them. The rest will be on your paperwork. You'll be responsible for looking at your paperwork. At a minimum, it'll say, don't drive without a valid driver's license, no drugs no possession of drugs without a valid prescription. If I do set a security appearance bond, you will be able to go through bondsmen. It's my understanding they do collect calls. A number of the walls on the jail are names and numbers of the bonding companies. If you can't find them or you need some help, ask one of the officers for help. All right. David Romano. All right, sir, your name and date of birth, please.
May 29th, David Andrew Romano, May 29th, 1992.
All right, so you got 3 matters before me, and let me just go with them right here. 2 of them are bench warrants, okay? They were in 2026, 1188370. You had your initial appearance on 5/20/26, and CR 2026, 11685 you initialed on about 5/7/2026. Both of them are shoplifting and dangerous drug charges, and you already have an attorney on these cases. We have the same attorney as your new case, by the way. And your court dates will be July 22nd for a status conference at 8:30, and a witness preliminary hearing on July 24th at 8:30 at 175 West Madison. You cannot return to scene of alleged crime, and you cannot initiate contact with any complainant or witness. And your judge in those cases set bond for each one, a security appearance bond of $250 each, $500. Now we have the new case in 2026127439, possession of dangerous drugs for sale, possession of dangerous drugs and possession of drug paraphernalia. On the possession for sale of dangerous drugs, based on limited information, I don't find probable cause. I don't have enough information on it. Doesn't mean you won't be charged with it, but I do find probable cause in regard to the other 2 charges, dangerous drugs and drug paraphernalia. As I said, appoint a lawyer for that one, same court dates 7/22 and 7/24. Now, I mentioned I found what your release dates, initial appearance dates were to other 2 cases. So pursuant to Rule 7.2B and Article 2, Section 22 of the Arizona Constitution, at this point you'll be held without bond. You'll have an evidentiary hearing on July 23rd at 1:30 at the West Madison courthouse to determine whether bond can be set. Your attorney will explain that to you, what's involved. But at this point, you'll be held without bond. So step to your left, please. All right, Casey Doherty. And so your name and date of birth, please?
Casey Michael Doherty, 10687.
Okay, how long you been in now? Since July 9th?
Yeah.
Okay, you're being held on a $100,000 bond?
Yeah.
On an armed robbery case. Okay, this is an arrest warrant, for a robbery charge. It's, alleged to have occurred 7/9/2026. I just want to double check one thing though. Okay, I just want to make sure there weren't, it was just another charge added to the other one, but it's not.
They lowered it, or they dropped it down to a robbery?
No, it's two separate things, both alleged to have occurred July 9th. The one on the when you're being held in custody is what had Harris Bank, PMO, whatever it is called, Harris Bank. This one appears to be with nothing to do with the bank. Looks like
Nothing to do with the bank?
what? Well, it doesn't the bank's name, and it just mentions a person's name on it.
Oh, okay.
So straighten out with your lawyer. Another judge said bond for you at this point, and for $100,000 on this also. And I did appoint a lawyer. You'll be at 175 West Madison Street on July 22nd at 8:30 for a status conference, and tentatively scheduled for a witness preliminary hearing on July 24th. Also, an ankle bracelet was also put on you if you happen to get out. See, next court date is July. Oh, so it's going to be the same date as. You got a witness preliminary hearing scheduled on the 22nd also, but there's a good chance it may not go. Your lawyer can explain that to you. But this one will have a status conference on July 22nd.
Okay.
All right, and so you'll talk with him, and he or she can talk about whether the bond can be see if they can ever reduce at this point. But obviously, you haven't made the other one. But
Yeah.
all right, okay. Step to your left, please.
Appreciate it.
Samuel Cesarini. And so your name and date of birth, please.
Samuel Cesarini, 012495.
Okay. You are charged with 6 counts of possession of dangerous drugs for sale and 1 count of possession of narcotic drugs for sale, all class 2 felonies. I will tell you this, the prosecutors were asking for a $250,000 cash bond on this. I'm not going to do that much. What I'm going to do is, first of all, appoint a lawyer for you. You'll have a status conference on July 22nd at 8:30. Witness preliminary at this time is scheduled for July 24th at 8:30 at 175 West Madison Street. I'm setting a cash bond of $100,000, but if you post your bond, you'll have an ankle bracelet on you with a curfew. You go home during hours approved by pretrial services. Okay. All right. Step to your left, please. Haki Baguma. So your name and date of birth, please.
Akili Baguma, February 1st, 1999.
All right, so you're charged with aggravated assault, a class 3 felony. Sir, are you working? That's a no, right? You're just shaking your head no. If the answer is no? All right. For the record, he shook his head no, because you hadn't you just declined to speak with pretrial services. So I am going to appoint a lawyer for you.
Sir?
I am going to appoint a lawyer for you. That's why I was asking that question. All right. Your court dates will be also 175 West Madison Street, status conference on July 22nd at 8:30, and a witness building hearing on July 24th at 8:30. You cannot initiate contact with the alleged victim. You can't possess any weapons. And Dave was asking for a $75,000 bond. I'm going to set his security appearance bond about $30,000, so you can go to the bondsman. All right, step to your left, please. George Ferrara.
Yes, sir, Your Honor.
Okay. Not good evening, good morning.
Morning.
Your name and date of birth, please.
George Michael Cletus Pereira, born June 3rd, 1988, sir.
Okay. Sir, first of all, you are charged with 1 count of aggravated assault, class 3 felony, and 1 count of possession of a weapon by a prohibited person, a class 4 felony. Likewise, your court dates are at 175 West Madison Street at 8:30. Status conference on July 22nd, and tentatively a witness preliminary hearing is set for July 24th at 8:30. You cannot have any contact with any alleged victims. Can't possess any weapons. All right. And bond for you. Let me just see here. The state is asking for a $50,000 bond. I'm going to reduce it to a $25,000 security appearance bond.
Oh, yes, sir?
I'm lowering it to 25,000, not 50.
I'm barely a blue-collar tow truck operator. I can't
Okay.
afford that.
Well, you can talk to your lawyer and see if that can be reduced, okay? Step to your left.
Yes, sir.
Day of work, that's another. Michael Herrera? So your name and date of birth, please.
Michael Raymond Ferreira, January 24th, 1977.
Okay, sir, in your situation, you have 4 matters. 3 of them are from out of the county warrants, okay, and then 1 new case here. Let's just deal with the case that's here. That's in 2026 127-433. Possession of narcotic drugs, possession of dangerous drugs, and possession of drug paraphernalia. You may also have a warrant out of Payson PD. But anyway, on this one, I'm appointing a lawyer for you. Your court dates will be 7/22 at 8:30, and witness bond hearing on July 24th, 175 West Madison. Because you have 3 out-of-county warrants, which they said bond, I want you to be able to possibly get credit for this charge also at the same time. And so I said bond amount of $100 security appearance bond on that one. Okay, otherwise I probably wouldn't have, held you, setting bond on that. So let's just deal with the out-of-county ones, which I know nothing about. I just know the charges, so you know. 2026 000293. That's at a Gila County Superior Court. Narcotic drugs, dangerous drugs, drug paraphernalia, and taking contraband in a correctional facility. If you didn't have one already, I'm directing that an attorney be appointed for you at the next hearing. Your arraignment hearing is scheduled for July 21st at 8:30 at the Gila County Superior Court. The address will be there. I don't know if that gets affected by your local charge or not. Okay, just let's talk to your lawyer here about that, and maybe he or she can answer it. And they said bond in the amount of $5,000 security appearance bond on that one. Then we have another one out of Gila County, 2025 00377, a burglary in the 3rd degree, Once again, appointment, it'll be July 21st, 8:30. And, he cannot return to the scene of the alleged crime or initiate contact with the alleged victim. And they said bond amount of $2,500 security appearance bond. And finally, in 2026-00178, once again, at a Gila County Superior Court on a shoplifting, once again, directing a lawyer to be appointed for your next court date, same court date, don't return to the scene of alleged crime, etc. And they said bond amount of $2,500. So that's, I think, $1,100 security appearance bond, but you got two different courts to go to. All right, step to your left, please. Eugene McMeekin. Yes, sir. Your name and date of birth, please.
Eugene McMeekin, November 2nd, 1968.
All right, so you're charged with 2 counts of trafficking and stolen property in the 1st degree, class 2 felony, and 1 count of burglary in the 3rd degree. I can change that. That's a class 4 felony, not a class 3 felony. So give me 1 second. Actually, maybe before I do that, let me just check something else. Right. So if I said it was a class 3 before, it's really class 4, the burglary charge. So I'm just changing it there. So I did appoint a lawyer for you. You'll be at 175 West Madison Street for a status conference on July 22nd at 8:30. Witness preliminary hearing set for July 24th at 8:30. I did, as I said, appoint a lawyer for you. You cannot return to the scene of alleged crime. You cannot have any contact with any co-defendant. Okay, and bond is set in the amount of security appearance bond of $3,600. All right, step to your left, please. Angela Romero. Your name and date of birth, please.
Angel Sarah Romero was born on 03/05/2001.
Okay, you got 3 matters before me. One is a probation violation. Based on an aggravated assault to Mr. Brown's charge, you're alleged to violate terms 1, 2, and 3. I did appoint a lawyer for you on this one. That's in 2023, 124,981.
Misdemeanor, right?
No. Actually, if you want, I'll look it up right now here.
In 2023, I was incarcerated.
I know. Now, this is based on a probation violation. Indicating that it's a class 6 felony. I'll delve in a little bit further on that. Okay, give me a second.
Things are class 5.
Hold on a second. Apparently, you plead guilty to a robbery charge and assault. It said assault. Should be, but it's 13-1203, which is aggravated assault. Okay, as a class 6 felony, and looks like you went to DOC on one of them, right? And then probation on the other.
Yeah, I went to DLC.
Yeah, that's what I'm saying. But it was, you said it was a misdemeanor, and no, it's a felony.
No, like when I was incarcerated, the 4 misdemeanors I got, but this is not misdemeanor court, this is felony court. So,
okay, I just wanted to let you know this. I'm just looking, sensing, and because you did ask me, I just want to give you the courtesy of double checking for you. Anyway, And you'll talk to your lawyer about any issues you have. Your revocation arraignment hearing will be at 201 West Jefferson on July 22nd at 8:30. As I said, you're alleged to violate terms 1, 2, and 3. If you get out, these following things apply to all your matters. If you get out, contact your probation officer within 72 hours. Can't possess or consume any alcohol, no weapons, no drugs without a valid prescription. And a judge down a probation violation set bond for you in this one in the amount of $2,500. Now, you have a new case, 2026 127432. You're charged with aggravated assault, class 4 felony, aggravated domestic violence, and disorderly conduct. I don't have enough information in regard to the aggravated domestic violence charge. So at this point, I'm not finding probable cause on that part. Doesn't mean you won't be charged with it because they didn't set forth the 2 previous convictions, okay, in regard to it. But I appointed a lawyer for you on this one. This one won't be at 201 West Jefferson. It'll be at 175 West Madison on July 22nd at 8:30 for a status conference. Witness preliminary hearing is on July 24th at 8:30. So if they're at the same time, you can't be taken to both places. So talk to your lawyers about it. Ultimately, both cases will be brought to the same courthouse, probably at 175 West Madison.
On what date? 24th or 22nd? On what date? 24th or 22nd?
Well, the status conference is 22nd. Witness preliminary hearing is set for the 24th. And then the probation violation, it's set for July 22nd, the same time at 8:30 also.
So I could most likely get released from probation on the 22nd, if that's up to them.
To be released, what do you mean released? To me,
The probation has a hold on me right now.
oh yeah, right. That's what I'm saying.
So if
That's
I want to,
$2,500
so I could get the hold off for $2,500.
if you post on that one. Now, on the new charge, that's what I hadn't gotten to it yet. I see the point of lawyer for you. There's another. You cannot return to the scene of alleged crime. You cannot initiate contact with the alleged victim. You're allowed one civil standby with law enforcement to collect your essential belongings. And once again, I told you about contacting your probation officer within 72 hours release, etc. And bond on that one is also $2,500. Now you have also a warrant out of the Goodyear City Court. The address will be in your paperwork for disorderly conduct and criminal damage. A lawyer will be appointed for your next court date. And it's scheduled there at the same date, 7/22 at 8:30. So you got to talk to your lawyer about these 3 different places at the same time. Because bond was set in the other matters, I set bond in the amount of $250 on that one.
So altogether,
$52.50, but you'd have to be at 3 places at the same time. But you'd have to probably talk to your lawyer on the new charge first.
So I just have one question. I could bond out right now, or I could bond out after the 22nd.
Of course.
I could bond out right now.
Sure.
I don't have no hold on me.
No, you do have the bonds, 3 bonds.
Yeah, but there's no other hold on me. No probation hold, nothing.
There is a probation hold. That's why one of them was a $2,500 bond.
So after I pay the $2,500, the hold comes off?
On the probation, but then you have $2,500 on the new charges and $250 on the Goodyear warrant.
So can I?
Total bond is $5,250.
And can I put up a title?
It's between you and the bonding company. Okay.
Appreciate you.
Okay. I said I tried to explain as much as I can, but
Yeah,
okay.
I'm slow, bro. So
It's all right. No, you're doing fine. Okay. Valerie Balboa. Hi, good morning. Your name and date of birth, please.
Valerie Balboa, H2393.
Okay. Can you hear? Because I was talking over there. Can you still hear? Can you hear me?
A little bit.
All right. I'll talk a little louder now. And the talking's gone. So you're here on 2 matters. First of all, in 2025, 120602, you're here on a probation matter. Looks like you're on probation for possession of drug paraphernalia alleged to violate terms 3 and 5. I appointed a lawyer for you. You have your revocation arraignment hearing on July 22nd at 201 West Jefferson. If you get out, this applies to both of your cases. Contact your probation officer in 72 hours. You can't possess or consume any alcohol, no weapons, no drugs without a valid prescription. And bond on that was set by a judge down a probation violation in the amount of $150. Then you have an arrest warrant on 2026 115675002, possession of narcotic drugs. I did appoint a lawyer for you, and your court date will be July 22nd at 8:30, 175 West Madison, which unfortunately is the same time as the other one, so you'll talk to your lawyer about that, all right? So, so keep your paperwork in regard to that. And and the preliminary hearing stuff, which is July 24th at 8:30. And same other release conditions such as contact your probation officer in 72 hours. Because you got a bond was set in the probation violation, so you could possibly get granted for both. I said bond on this one, an amount of $50. Okay, step to your left, please. For Fernando Guerrero. All right, so your name and date of birth, please.
10/15, Fernando Guerrero, 10/15/1993.
All right, you got two matters. One is a bench warrant, actually, based on a probation violation. Looks like you're alleged to have violated terms 1, 3, and 5. And so you appoint a lawyer for you. For this one, you'll be at 201 West Jefferson for revocation and arraignment hearing, July 22nd at 8:30. And this applies to both matters. If you get out, contact your probation officer in 72 hours, because that you're not to possess or consume any alcohol, no weapons, and no drugs without a valid prescription. Now, then you also have a new case for possession of drug paraphernalia. I appointed a lawyer for you. Unfortunately, you'll be a different building, 175 West Madison, for a status conference on July 22nd at 8:30. So tell your lawyer about the probation violation also. And then you'll witness preliminary hearing on July 24th at 8:30. And because, you okay, sir?
Yeah.
Okay. I just said, so you can get credit for both charges. I said bond of $50 on this one.
So what was it?
$50 on this one. And the total bond is,
what's the charge or the
possession of drug paraphernalia. You have to wait and see if the state files charges on that, but you also have the probation violation.
And then what's the how much do I
Okay, on the probation violation, it's $2,500, and on the other one, it's $50. So $2,500 and $50 secured appearance bond. Right?
Okay.
And you can go to a bondsman.
And then when do I speak to my probation officer?
Well, if you get out, you got to contact him or her within 72 hours of release. But you'll talk to your lawyer when you get to court, obviously.
Okay. And then
yeah, go ahead.
Oh, when I get out, or if I get out?
If you get out, contact your probation officer. It'll be in your paperwork.
And so then, how much time is it?
Well, I told you your court dates will be on July 22nd.
Huh?
Okay. Your court dates are in 6 days.
Oh, okay.
Okay. Step to your left, please. Vincent, Tabile. Tabile. Okay. All right, so your name and date of birth, please.
Vincent Tabile, 9/12/85.
Okay. So you got a warrant out of this El Centro Justice Court. The address will be on your paperwork. It's a warrant out of public nuisance. You have to be there on July 30th at 9:30, and I'm releasing you on your own recognizance. You'll be down to 46 hours. Show up there so you don't have to come back here, okay? All right, step to your left, please. Alexander Sabi. So your name and date of birth, please.
Alexander Sabi, August 14th, 1987.
Okay, so you have a new case out of Santan Justice Court. The address will be in your paperwork for threatening, intimidating, and disorderly conduct. I am appointing a lawyer for you. Your next court date is August 4th at 9 o'clock. Hold on 1 second. You're not returned to scene of the alleged crime. You cannot initiate contact with the alleged victim or victims. You're allowed one civil standby with a law enforcement officer to collect your essential belongings. You can't possess any alcohol. But however, I said you may initiate contact and or return to the scene of the alleged crime only with a prior written permission of the alleged victim. So I added that aspect to it. But okay, all right, but you'll be released on your own recognizance.
Thank you.
That's all. So we just have the house call. That's Jonathan Turk.
Yes, this is Jonathan Church.
Yeah, let's see, he was what is the reason, just a high profile, what is the reason why he's in ISO?
ISO, he would have been an ISO because pretty much he's closed custody right now.
Because because the nature of the charge?
Yeah.
And there's no way of safely bringing him into courtroom?
And because of the closed custody and the nature of the charge, they wouldn't want to.
I know, I'm just saying, is there any, with safety to officers and everybody, can he be brought into the courtroom? If you want to check with the other officer about that, I don't know.
Yeah, I can check.
Because, I have to make a finding, there's a reason why they're not brought in. Okay. Much lighter calendar, thank God. Tired.
Sir, I was told, no, because of violence issues.
This is what?
Violence?
Was violence, okay. I have to set a reason for it, that's all. He's got a grand jury indictment charging him with attempted murder in the first degree and class 2 felony, aggravated assault, class 4 felony, disorderly conduct, class 1 misdemeanor. Appointed a lawyer for him, and his arraignment hearing will be on July 23rd at 8:30 at 175 West Madison. And basically, his bond was set in a cash bond of $1 million.
so you don't even know. Or you're locked into it better. Got it. Understood. I like how. They can find everything else later. Oh, really? Good.
All right. Thank you. You may be seated. Good morning. This is the time set for the 8 a.m. initial appearance calendar on July 16th, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I will call you each one at a time to the podium. I'll provide a second name to sit in the chair outside of this room. I will let you know what you are here for, if I've appointed an attorney, if you have a bond, and what your release conditions are. And counsel, are you ready?
Yes, Your Honor.
All right, we'll go ahead and start since we have both attorneys here. We'll go ahead and start with number 17.
Thank
If we
you.
could have Kia Costa to the podium and Luis Moreno to the chair. All right, may I get your name and date of birth?
Good morning, Your Honor. Kia Costa,
And your date of birth, ma'am?
3/22/96.
Thank you. And counsel, can I get your appearance?
Yes, Your Honor. Good morning. Michael Zeitzen appearing this morning for just this proceeding only. So we would ask that any future proceedings should be appointed to the public defender's office.
Thank you, counsel. And the state?
Good morning, Your Honor. Dawn Sauer on behalf of the state.
Thank you. And I do believe we have a victim here. Can I get your name?
Vega,
I couldn't hear you. I'm sorry.
Oscar Vega.
Thank you, Mr. Vega. And I am going to go over the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, thank you everybody for your appearances. We are here today on a new case. It is for one count of aggravated assault with a deadly weapon or a dangerous instrument, a Class 2 felony, and one count of disorderly conduct, a misdemeanor charge. Counsel, did you want to be heard today on probable cause, release conditions, or both?
Release conditions, Your Honor.
Thank you, counsel. The court is going to find probable cause for purposes of today. I have noted that you have hired an attorney for the initial appearance only, so I am finding that you are indigent and appointing an attorney to represent you at future hearings, okay? Next, we're going to discuss any hearings you may have and any bond and or release conditions. But before I do that, I do want to hear from all the parties. And counsel, did you get an opportunity to review the state's recommendation?
I did, Your Honor.
Okay, thank you. And Ms. Sauer, was there anything you wanted to place on the record?
Yes, Your Honor. The state does believe the victim is a danger. I'm sorry, that the defendant is a danger to the victim. She assaulted the victim repeatedly. She kicked him. She punched him multiple times. That wasn't enough. She went and got a hammer. She attacked him with a hammer, striking him in the left rib area. The Form 4 indicates that this was all caught on ring camera, and it was observed that the victim visibly folded over and cleaned when struck with the hammer. She continued, looks like she tried to hit him again with the hammer, but the victim managed to deflect. When the officers tried to contact the defendant, she refused to answer the door. She was uncooperative. The state believes this is an indication of potential flight risk. And she also, I think it was page 2 of the Form 4, there was indications that she planned to go to Yuma. The state's asking for a $35,000 secured appearance bond. and it posted electronic monitoring, no returning to the scene, no contact with the victim, no firearm. There was one other thing I was trying to find. It's not clear to the state whether the victim continues to live in that apartment or not. Also, the form mentions that there were injuries consistent with the assault that was seen on the Ring camera, although the state isn't clear the extent of the injuries at this time. Thank you.
Thank you, Ms. Sauer. Mr. Zeiton?
Your Honor, thank you. Good morning. Your Honor, the residence was my client. The alleged victim in this case was a guest. And the probable cause obviously has a single-sided version of what happened. What I want to submit to the court is, on her behalf, that she's not a flight risk. She had an established residence. She had employment. And as a result of this incident, she has now lost the residence, and it doesn't belong to the victim, and he doesn't reside there. Her needing to move back to her hometown is where her family is. So that's where she needs permission, Judge, to be able to reside in Yuma. We further respectfully ask you not to impose a bond. If the electronic monitoring is a thought by the court, pretrial services can adequately monitor this situation. It involved a relationship, and there's no history of flight risk or any indication that she's going to run from this court proceeding. So with electronic monitoring and pretrial services, that should be adequate. And she's hoping that in order to get back to Yuma, she can then transfer her work too. So she has to migrate back to Yuma because of this incident, because she can't obviously afford staying here in the Valley at this point. And that's exactly what hopefully the court will allow her to do. She will not have contact whatsoever with the victim. Is that correct?
Correct.
And she can get the necessary assistance that she'll need for her health and well-being as well, Judge.
Thank
So
you.
I just submit to you to please look at the facts that at this point it's a single-sided situation right now.
And counsel, based on that, it appears as though she still has her job. She's just lost the apartment. Is that correct?
That's the hope, Judge. I believe that's, I don't have any evidence of that, but that's the plan and the purpose of why she would be going back to Yuma.
Okay. And then based on your comments, it's an employment that would potentially have a location there, or it's a virtual. So if she were to go to Yuma, there's a possibility the job could remain.
Is that correct?
Yes.
Okay.
Thank you. And Mr. Vega, is there anything you would like to tell the court before I make a decision as to whether or not there should be a bond imposed?
Yes, Judge. Please bear with me with this. I've never done this before, nor have I ever thought I'd be in this situation. But as I made my statement, I personally, I'm sorry, it's just a lot of emotions right now for me. Please bear with me. I personally, I never thought I'd be in this situation. I don't believe she's a flight risk at all. I don't believe she's a danger to the public at all. I personally, I know it's a very hard situation, and it's, you know, what she did is something that's very serious. And personally, for me, like, I don't want to press charges at all. But I do believe that, you know, based on everything, like, there has to be consequences for her actions, because there's no reason for that in general. There's no reason to pick up a hammer and hit somebody with it. I want to make it clear that like I said in my statement before, I don't believe prison time or anything of the sort is necessary. I do care about her still, even after all this. I just hope that she and I could both move forward. She can move forward with her life, and I could move forward with her life, because I don't want to see her in prison at all. I don't. I get that this is something very serious, and, you know, it ended up happening, but I do believe that she is not a flight risk at all. She's not a danger to the public, and that given that everything that has happened, like even after everything, I do care about her, and one thing that I do want to request is a restraining order. And other than that, that's pretty much it, Judge. Like I said, I never thought I'd be in this situation before in my life. I never thought it would come down to this. But again, what she did was not right at all. There should never have been a reason to hit somebody with a hammer or try to hit somebody with a hammer in any shape, way, or form. But when it comes down to it, it's out of my hands at this point. But whatever you decide, it is what it is. But those are my thoughts. Those are my opinions on this particular case. And I'm sorry, it's just a lot for me right now. It's a whole mess of emotions, but that's pretty much all I have to say for the matter at hand.
Thank you, Mr. Vega. Thank you for providing that information to the court. So I have reviewed the allegations in this case, along with your criminal history. I do note there are no prior failure to appear. There are no prior felony convictions. It looks like the last conviction you had was related to a misdemeanor charge from 2021. I do have some concerns as it relates to the safety of the victim. I do believe that you pose a danger to the alleged victim in this case. However, when I take everything into consideration along with the information he has provided here today, I am going to release you today to the supervision of the pretrial services. Because you are requesting to go to Yuma County, outside of Maricopa County, and there are no prior failures to appear, I'm not going to do ankle monitoring because they cannot monitor you outside of Maricopa County. So I am going to include information that you may travel to Yuma County if that's where you end up needing to reside as it relates to the current situation. You are going to receive paperwork and an envelope. In that envelope, you're going to be given instructions as it relates to pretrial services. You must contact them within 72 hours of your release. I'm also going to give you some hearing dates. They are going to be here in Maricopa County, so you will have to make yourself available to appear here in person. Your next hearing is a status conference on July 30th at 8:30 in the morning. You're going to have a preliminary hearing August 3rd at 8:30 in the morning. Release conditions are going to include no contact with the alleged victim, no contact with any complainant or witness. I am going to order that you must obey the terms of any order of protection that may be issued against you. In addition to that, you are not to possess or consume any alcohol, and you're not to drive a motor vehicle without a valid driver's license, okay? All of this will be in your paperwork. Counsel, any questions?
No, Your Honor. Thank you.
All right. Ms. Sauer, anything further from you?
No, Your Honor, thank you.
Mr. Vega, did you have anything further for the court?
Not really too much. The only thing I want to say is that even after everything that has happened, I forgive her, and that like I said, I don't believe she's a risk to anybody. Other than that, I do hope that as a part of her getting released, she goes to counseling for anger management. And that's pretty much all I can say at this point, Judge. There's so much emotions going through my head right now. My heart's beating out of my chest as we speak, and it's really intense. Like I said, I've never had to do this in my life before. I never thought I'd be in this situation. Like I said, I do care about her. I do, even after everything, even after getting hit. But, you know, at the end of the day, like, there's always have to be consequences for those actions, because there's never a reason to hit somebody with a hammer. But, yeah, I just hope you take my words into consideration in the future, and the court takes my words into consideration into the future. Because in all honesty, like I said, I don't want to see her in prison. I don't want her to go through any of that. It's just, you know, one bad day and things happen, and luckily for me, like I didn't go to the hospital, none of that, but at the end of the day, I did get hit. So, but as far as that's concerned, just whatever you see deemed fit, but those are my words, and that's all I have to say on the matter.
Thank you, Mr. Vega. And to address your concern earlier as it relates to the request for a restraining order, if that's something you're interested in doing, talk to Victim Services about moving forward with that. I cannot grant that here at this hearing today. However, I have included language in the release conditions that if one is granted, she will be required to comply with all terms and conditions of that as well. This does conclude our hearing. We'll get you a copy of the release conditions. You can use that room to speak to your client if you would like, okay?
Thank you, Your Honor.
Thank you,
Good morning.
counsel. Thank you, Your Honor. And thank you, Mr. Vega, and thank you, Ms. Sauer. Is that the only case you're appearing on?
No, Your Honor. I'm appearing on number 26.
20. Okay, perfect. We'll do Mr. Moreno to the podium, and then we will do Mr. Rodriguez to the chair.
Number 10. Hi there, Lauren.
Can I get your name and date of birth?
Luis Aaron Moreno, 10-395.
Thank you, sir. It does look like you are here today on two cases. You're here today on a new case, as well as a failure to appear bench warrant that was issued for you. Your new charges are for 1 count of dangerous drug possession and 1 count of narcotic drug possession, both class 4 felonies. Probable cause has been found, and I'm appointing an attorney to represent you. On the case you failed to appear, it is for a pending case for narcotic drug possession and drug paraphernalia possession. I am going to affirm the attorney previously appointed. I'm going to set 3 hearings in these cases. You're going to have a status conference July 22nd at 8:30, an evidentiary hearing July 23rd at 1:30, and a preliminary hearing July 24th at 8:30. On the case where you failed to appear, you do have a secured appearance bond in the amount of $100. However, on your new case, because you were out on felony release at the time of the alleged offense, you're not eligible for bond today on that new case. So posting the bond on the failure to appear case is not going to get you released until you have your evidentiary hearing on July 23rd at 1:30. That's the time set to determine if bond will be set on your new charges. So that means you'll be in custody until at least that hearing date. Did you have any questions? If you'd like to step to your left, the officer will get you that paperwork.
There you go.
Mr. Rodriguez to the podium and Mr. Roberts to the chair. I don't think that's the right Rodriguez. I'm sorry. I'm looking for a Michael Rodriguez. He may be the one in the white hat. Thank you.
Your hot dog. Yeah, right there.
May I get your name and date of birth?
Michael Lee Rodriguez, 12/10/77.
Thank you. And can I get the state's appearance?
Dawn Sauer on behalf of the state, Your Honor.
Thank you, Ms. Sauer. Sir, you are here today on 2 cases. You're here today on a new case as well as your probation case.
Mm-hmm.
Your new charge is for 1 count of murder, a class 1 felony, and 1 count of concealment of a dead body, a class 5 felony. And then because you were on probation at the time of this alleged offense, you're here on a term 1 probation violation. I am finding probable cause and appointing an attorney to represent you in these cases. I'm also going to give you some hearing dates. You are going to have 3 hearing dates coming up. They are 3 days in a row next week. You're going to have a status conference July 22nd at 8:30, a probation revocation hearing July 23rd at 8:30, and a preliminary hearing July 24th at 8:30. Next, we're going to discuss any bond and or release conditions that you may have. But before I make my decision, I would like to hear from everybody in court. And so I'm going to start with the state. Ms. Sauer?
Thank you, Your Honor. The state believes the defendant is in extreme danger to the community and a flight risk. He killed his father. It was quite violent. He hit him on the head with a bar. Looks like he strangled him. He admitted that they would find prints around his neck. The victim was found with plastic over his head. The defendant has multiple convictions in his criminal history, including 3 weapon offenses and an unlawful flight. He threatened the witness, and the state is concerned about the safety of the witness. He concealed the body. He concealed other evidence as well. He put the victim in a pit, covered him with wood. He disposed of the shoes that he was wearing, which will interfere with law enforcement matching it with the footprint that was found. He also admitted that the bar that he used to hit the victim in the head would no longer be at the scene, so that must have been disposed of as well. There is strong evidence in this case. He's facing a long prison sentence. He has incentive to flee, and he has incentive to harm the witness.
No, I don't, Your Honor.
I'll give you an
I
opportunity
stayed there the
to
whole
speak
time,
in
Your Honor.
just 1 moment, okay?
I stayed there the whole time.
Just 1 moment.
He also has numerous FTAs in his criminal history. The state is seeking a $2 million cash-only bond and is also requesting, if posted and released, electronic monitoring and no contact with the witness, obviously. And on the probation violation matter, the state is asking that he be held non-bondable.
Thank you, counsel.
Thank you.
So, Mr. Rodriguez, I am going to give you an opportunity to speak. I do want to let you know that I have appointed an attorney to represent you. That attorney is not here today. You're going to meet with that attorney at your next hearing. Everything you say right now is being recorded as well as live streamed. And as you're aware, the prosecutor is here today. So I want you to be careful with things that you may say that you may not want to say without the advice of counsel. Further, I have already found probable cause as it relates to the alleged charges in this case. So right now we're only discussing whether or not there should be a bond and what your release conditions should be. So is there anything you would like to tell me as it relates to any bond that should be imposed and any release conditions you should have?
So I should just watch what I say right now, right? But I already said what I said. I mean, and I didn't go nowhere. You know who my dad is? Do you guys even know who my dad is? Head of la familia. That's who he is. That's who he was. A bad dude. A bad man. I had to stop everything he was doing. Everything. You know what I mean? And
Okay.
no one else could do it but me. And that's why I stuck around. I mean, I didn't go nowhere.
And is there anything you would like to say as to whether or not there should be a bond and your release conditions?
And there shouldn't even be a bond. I mean, I didn't go nowhere, Your Honor. And I didn't threaten that witness. I approached him. I want to know where he came from. How he ended up in El Mirage. That's all I asked him. He started spilling the beans. He started shaking like a little dog. You know what I mean?
Okay, so you're indicating that you don't believe you're a flight risk.
I'm not a flight risk, Your Honor. I didn't go nowhere.
Thank you for that, Mr. Rodriguez. I have reviewed the allegations in this case. I've also reviewed your criminal history. I do note that you do have 8 prior felony convictions along with 4 failure to appear. I do have some concerns regarding the allegations that were alleged in this case, along with the allegations that there was potentially some witness intimidation. So based on that, I am going to set a cash bond in the amount of $2 million on your new charges, $1,000 on your probation case. In the event you were to post that bond and be released from custody, you would be released to the supervision of pretrial services and you'd be equipped with electronic monitoring. You'd also have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. And because you're on probation, you must contact your probation officer within 72 hours of your release. This will all be in your paperwork, sir. If you will take a step to your left, the officer will get you that paperwork.
Okay.
May I be excused, Your Honor?
Yes, thank you, Ms. Sauer.
Thank you.
Judge, have a good morning.
Thank you, you too. Can I have Mr. Roberts to the podium and Mr. Paredes to the chair?
Okay.
Can I get your name and date of birth?
Dorian Roberts, 1/17/1973.
Thank you. It does look like you are here today on a new case. It is for 1 count of narcotic drug possession for sale, a Class 2 felony, 1 count of possession of a weapon by a prohibited person, a Class 4 felony, 1 count of possession or use of a weapon in a drug offense, a Class 4 felony, 1 count of discharging a firearm in city limits, a Class 6 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference July 22nd at 8:30. and a preliminary hearing July 24th at 8:30. In this case, you do have a cash bond in the amount of $35,000. In the event you post that bond and are released from custody, you do have written conditions. Well, in addition to being released to pretrial services, you'll be equipped with electronic monitoring, but your release conditions include not returning to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. You're not to possess weapons, and you're not to possess or consume any drugs without a valid prescription. This will be in your paperwork, sir. Did you have any questions?
It's almost my bond.
You have a $35,000 bond. Anything further? If you'll take a step to your left, the officer will get you that paperwork. Juan Paredes to the podium and Clayton Jeffrey to the chair. May I get your name and date of birth?
Yes, Juan Carlos Paredes, October 9th, 1984.
Thank you, sir. You are here today on a new case. It is for one count of theft, means of transportation, a Class 3 felony. One count of possession or use of a weapon in a drug offense, a Class 4 felony. One count of possession of a weapon by a prohibited person, a Class 4 felony. One count of dangerous drug possession, a Class 4 felony. And one count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference July 22nd at 8:30 and a preliminary hearing July 24th at 8:30. In this case, you do have a secured appearance bond in the amount of $20,000. In the event you post that bond and are released from custody, you do have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you're not to possess or consume drugs without a valid prescription, and you're not to possess any weapons. That will all be in your paperwork, sir. Did you have any questions? Please take a step to your left, and the officer will get that for you. Clayton to the podium and Jason to the chair. May I get your name and date of birth?
Clayton Jeffrey, 7/12/78 now.
Thank you, sir. It does look like you are here today on two cases. You are here today on a new case as well as your probation case. Your new charge is for one count of misconduct involving weapons, a Class 4 felony. And then because you were on probation at the time of this alleged offense, you're here on a Term 1 probation violation. I am finding probable cause and appointing an attorney to represent you. You're going to have 3 hearings coming up. You're going to have a status conference July 22nd at 8:30, a probation revocation hearing July 23rd at 8:30, and a preliminary hearing July 24th at 8:30. Your charges on your new case is one count of misconduct involving weapons, which is a violation of your probation. I am going to set a secured appearance bond on your new case of $15,000. Your probation case is $1,000. That is a total bond of $16,000. Hold on one moment. In the event you post your bond and are released, you do have written conditions. You're not to possess any weapons, and you must contact your probation officer within 72 hours of release. That'll be in your paperwork. It looks like you had a question, sir?
Yeah, how do I get, what happened is, at work, I got a new job and I work a lot. My boss's ex-husband was watching my dog. He would come over and check my dog for me and stuff so I can work. He's not a felon, not nothing. It's his weapon. It's registered. It's not stolen or anything. He forgot it. I guess the cop told me it was in the closet, secured in the closet outside the door. How do I get him to, who do I have him call to verify that he forgot his gun in my house? I was there for like 10 minutes. I got home after almost a week of working. It was just on there. It's not like I'm running around the streets or doing crime or anything like that. Who do I have him contact?
So when you meet with your attorney that I've appointed on July 22nd, let him know that that is your defense, and they can schedule an opportunity to speak with that person. Of course, you can hire your own attorney, of course, if you would choose.
No, of course.
If you don't, then of course you'll meet with the attorney that I've appointed on July 22nd. But that's the person that you would want to provide that information to, if that is the information you want to provide as your defense as it relates to this.
There's no way to get anything in reduction on my bond. Is it something I can reach? I'm not running the streets. I'm not doing no crime. I have a new job. I have my daughter out there. I'll still pay bond. I have no problem. Anybody can just get something a little lower, just some in my reach. I'm working. I just got a new car. I got my old car. I'm doing good. I'm not running the streets. My whole life I've always been in trouble. I've been doing good for 2 years. Please, if I can just get a little reduction on that, something I can reach. If I can. I'm from jail trying to even have with money. I'm not one of those guys that just run the streets and committing crimes. I'm working 24 hours a day. I work at a storage unit, I work at a car sales lot. I just don't want to lose my jobs. It's something I can reach, that I can, you know what I mean?
So it is a
Sure.
secured appearance bond, meaning you could use a bail bonding company. Bail bonding companies are typically 10% plus collateral on the bonds. The state was requesting a $50,000 bond. I've set it at $15,000. I'm not inclined to reduce it beyond the $15,000. The allegations in the police report do indicate that there may be some information that you may have known about the alleged weapon that was in this case. So I am going to leave the bond as it is today. If you post that bond, you'll be released from custody, but make sure you contact your probation officer within 72 hours.
Yeah.
Okay? If you'd like a step to your left, the officer will get you that paperwork. Jason to the podium and Cameron to the chair.
Sorry, Judge, Jason. Jason?
Can I get your name and date of birth?
Jason David Clisette, May 22nd, 1988.
Thank you. It does look like you're here today because a grand jury warrant was issued for your arrest. It has an offense date of September 24th of 2025, and it is for 1 count of armed robbery with a deadly weapon, a Class 2 felony, and 2 counts of aggravated assault with a deadly weapon or a dangerous instrument, a Class 2 felony. I am appointing an attorney to represent you in this case, and I am setting an arraignment hearing on July 23rd at 8:30 in the morning. In this case, you do have a cash bond in the amount of $5,000. In the event you were to post that bond and be released from custody, you would have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you're not to possess any weapons.
I was told that case was closed out.
So it looks like this warrant issued just very recently on July 9th, so about a week or two ago. And again, they took it before the grand jury, and the grand jury indicted you on that, and as a result, they issued this warrant for your arrest as it relates to these charges.
Did they take into consideration the extraneous terms?
Can you say that again?
Did they take into consideration the extraneous terms, the extreme terms of the situation?
So I don't know, and the reason I don't know is because grand jury warrants are sealed. So what that means is I have no information on the underlying facts of this case. The only thing I know is this warrant was issued based on the indictment. However, when you get to your next hearing, the case will be unsealed. The judge, as well as your attorney, is going to have the information that was presented. But for purposes of today's hearing, I don't have any information on the underlying facts, just that a grand jury heard evidence, they indicted you on that, and the judge issued this warrant for $5,000. So any information that you may have as it relates to what you were just mentioning, talk to your attorney about. You'll meet with them at your arraignment hearing. But for purposes of today, I don't know what information was presented. Okay? If you'll take a step to your left, the officer will get that for you. Cameron Bingham to the podium. And Michael Centeno to the chair. May I get your name and date of birth?
Cameron Bingham, 8891.
Thank you, sir. You are here today on a probation violation warrant that was issued with allegations that you violated terms 3, 4, and 5. I'm appointing an attorney and setting a probation revocation hearing July 23rd at 8:30. In this case, you do have a secured appearance bond in the amount of $2,500. In the event you post that bond and are released from custody, you do have written conditions. You're not to possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. That'll be in your paperwork, sir. Did you have any questions? Please take a step to your left, and the officer will get that for you. Michael Centeno to the podium and Cassandra Sandoval to the chair.
Hello, good morning.
What's your name and date of birth?
Michael George Centeno, 1889.
Thank you, sir. You are here today on a new case. You are here for 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, 1 count of carrying a weapon in the commission of a felony crime, a Class 6 felony, 1 count of disorderly conduct, a Class 1 misdemeanor, and 1 count of threat, a Class 1 misdemeanor. For purposes of today's hearing only, I am not finding probable cause for the dangerous drugs, the drug paraphernalia, or the carrying a weapon during the commission of a felony. The reason for that is I don't have enough information today as it relates to the substance that was located. That doesn't mean it's dismissed. They may test the substance that was located and move forward with these charges. I am finding probable cause for the disorderly conduct and the threat, and I'm appointing an attorney to represent you. You're going to have a status conference July 22nd at 8:30, a preliminary hearing July 24th at 8:30. In this case, you do have a secured appearance bond in the amount of $1,500. In the event you post that bond and are released from custody, you do have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You're not to possess weapons, and you're not to possess or consume any drugs without a valid prescription. This will be in your paperwork, sir. Did you have any questions?
Nothing.
Please take a step to your left, and the officer will get that for you. Cassandra Sandoval to the podium. Frank Filani to the chair. May I get your name and date of birth?
Cassandra Sandoval, 298.
Thank you, ma'am. You are here today because a failure to appear warrant was issued for your arrest relating to a pending case for narcotic drugs and drug paraphernalia. I'm going to affirm the attorney that was previously appointed to represent you and give you some new hearing dates. You're going to have a status conference July 22nd at 8:30, a preliminary hearing July 24th at 8:30. In this case, you do have a secured appearance bond in the amount of $500. In the event you post that bond and are released from custody, you do have written conditions. You're not to possess any weapons. You're not to possess or consume drugs without a valid prescription. You must also attend all of your future hearings. If you were to fail to appear again, another warrant would issue and you'd forfeit any bond you may have posted. That'll be in your paperwork, ma'am. Did you have any questions? Take a step to your left, please. Frank to the podium and Larry to the chair.
Good
Get
morning.
your name and date of birth.
Frank Filiani, 4267.
Thank you, sir. You are here today on a failure to appear bench warrant that was issued for you related to a pending charge of narcotic drugs and drug paraphernalia. I'm going to affirm the attorney that was previously appointed to represent you and give you some new hearing dates. You're going to have a status conference July 22nd at 8:30, a preliminary hearing July 24th at 8:30. In this case, you do have a secured appearance bond in the amount of $500. In the event you post that bond and are released from custody, you do have written conditions. You are not to possess or consume any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You also need to ensure that you attend all of your future hearings. If you fail to appear again, another warrant would issue and you'd forfeit any bond that you have posted. That'll be in your paperwork, sir. Did you have any questions?
Yeah, there was a reason I didn't show up at court. And I thought maybe I could be released due to that circumstance.
Did you contact your attorney or file anything with the court?
I did not.
So when you don't tell anybody or get permission, then warrants issue for your arrest. Was there a circumstance that prevented you from appearing?
Emergency. Yeah, my wife wound up in the hospital, and I was there with her that whole time.
When was she in the hospital?
The beginning of May.
So it looks like the hearing you failed to appear at wasn't until June 19th. So it sounds like it was after she had already been admitted to the hospital, if she was admitted in early May. It looks like you were in custody before this court on June 5th and given those hearing dates. So you will need to post that bond in order to be released, okay? If you'll take a step to your left, the officer will get that for you. Larry to the podium and Michael Juarez to the chair. Can I get your name and date of birth?
Larry Patton Jr., 4274.
Thank you, sir. You are here today because a probation violation warrant was issued with allegations that you violated terms 3, 5, and 15. I'm appointing an attorney and setting a probation revocation hearing July 23rd at 8:30. You do have a secured appearance bond of $400. In the event you post that bond and are released, you do have written conditions. You're not to possess weapons or alcohol, and you must contact your probation officer within 72 hours of your release. This will be in your paperwork, sir. Did you have any questions?
No.
If you'll step to your left, the officer will get that for you. Michael to the podium and Samuel to the chair. Can I get your name and date of birth?
Michael Waters, April 8th, 2001.
Thank you, sir. You are here today on a failure to appear bench warrant that was issued for you with a pending case for dangerous drugs and narcotic drugs. I'm going to affirm the attorney previously appointed to represent you and give you some hearing dates. You're going to have a status conference July 22nd at 8:30, a preliminary hearing July 24th at 8:30. You do have a secured appearance bond in the amount of $250. In the event you post that bond and are released from custody, you do have written conditions. You're not to possess or consume drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You also need to ensure that you attend all of your future hearings. If you were to fail to appear again, another warrant would issue and then you'd forfeit the bond. Did you have any questions, sir? If you'll take a step to your left, the officer will get that for you. Samuel Alvarado to the podium and Alfredo Ramirez to the chair. May I get your name and date of birth?
Samuel Alvarado, 613-1995.
Thank you, sir. It does look like you are here today on a warrant from the West McDowell Justice Court. I believe you were seen yesterday regarding some cases. This one is for failing to appear at a hearing with an underlying charge of driving with a license that was suspended, revoked, or canceled. I'll appoint an attorney and set an arraignment hearing in the West McDowell Justice Court, July 21st at 8:30. You do have a secured appearance bond in the amount of $100 in this case, so this would be in addition to the bonds that were given to you yesterday. In the event you posted the bonds and were released, you would have written conditions. You're not to possess or consume drugs without a valid prescription, and you're not to drive a motor vehicle without a valid driver's license. That'll be in your paperwork. Did you have any questions? If you'll take a step to your left, the officer will get that for you. Alfredo to the podium and Robert to the chair. What's your name and date of birth?
Alfredo Ramirez, 61792.
Thank you, sir. It does look like you're here today on a warrant from the Goodyear Municipal Court. I do have a question for you. This came over as a page 2 indicating that you were already at Watkins Jail. Are you currently in custody serving time? Do you have a bond, or are you getting ready to be released?
Yes, I'm serving 90 days. I'll be out October 9th.
Okay. So you've got still a couple of more months. Okay. So what I'm going to do on this case, it's for failing to pay some fines on a previous case for driving with a license that was suspended, revoked, or canceled. Since you're going to be in custody until at least October 9th, what I'm going to do is I'm going to appoint an attorney, and I'm going to set a hearing in the Goodyear Municipal Court for July 22nd at 8:30. I'm going to put a placeholder bond of $50. Don't post that because you're going to be in custody until October 9th. What that does, it ensures that you get credit for any time served as well as you're made available for that hearing on July 22nd. If you post the bond, you won't be able to go. They'll issue a warrant and then you'd forfeit it because you're serving time until October 9th. So again, it's just to ensure that they make you available for that hearing on July 22nd, okay? It looks like it's for just failing to pay some fines on a previous charge though. All right, any questions?
Will that be holding me back on my release date on October 9th?
No, it shouldn't affect your release date at all. The hearing's next week. And again, it's just a matter of failing to pay some fines. But if I don't put the bond on there, they won't make you available. But you can let that court know that you're currently serving time and they can remove the bond to ensure and then set a hearing after your release date. That's likely what will happen. I can't tell you what Goodyear will do, but that way, again, you get taken to that hearing, they can remove the bond, and then you should be able to be released on October 9th.
If my girlfriend could pay those fines I owe, can I just get dismissed, or can I just avoid that court date?
That is possible. I've included their phone number in there. So if you have somebody that's going to pay the fines, make sure that they let them know that you also have that hearing date so they can vacate it. Because it is only fines, that's typically what would happen is if you pay that balance off, then they'll vacate the hearing. But they need to be made aware that you have that hearing when those fines are being paid off so they know to get rid of that hearing date, okay? So if you have somebody doing that, I've included the phone number. Either you can call or you can have whoever's making those payments call and make sure they're aware that that hearing needs to be vacated.
Thank you.
Okay? Take a step to your left, the officer will get that for you. Robert to the podium and Hillary to the chair.
Robert Kaufman, right?
Yes. Can I get your name and date of birth?
Robert Kaufman, August 24th, 1975.
Thank you, sir. It does look like you are here today on a new case. You are here today for 1 count of dangerous drug possession, a class 4 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You have 2 hearings coming up. You're going to have a status conference July 30th at 8:30 and a preliminary hearing August 3rd at 8:30. I am going to release you today to the supervision of pretrial services, but you do have written conditions of release. You're not to possess any weapons. You're not to possess or consume any drugs without a valid prescription. With your paperwork, you're going to get an envelope. You need to make sure you read those instructions and contact pretrial services within 72 hours of your release. And then make sure you attend all of your future hearings. If you fail to appear at any of the hearings, a warrant would issue for your arrest, and then you'd be held on a bond. Did you have any questions?
So I'll be released today?
Yes, it takes about 4 to 6 hours. If this is the only thing you're being held on, then you'll be released in 4 to 6 hours, okay?
All right, thank you.
Please take a step to your left, the officer will get that for you. Hillary to the podium, Mr. Forger to the chair. Can I get your name and date of birth?
Hillary Savala, 11/21/74.
Thank you, ma'am. You are here today on a new case. It is for one count of possession of a weapon by a prohibited person, a Class 4 felony. One count of dangerous drug possession, a Class 4 felony. One count of carrying a weapon in the commission of a felony, a Class 6. And one count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference July 30th at 8:30, a preliminary hearing August 3rd at 8:30. I am going to release you today to the supervision of pretrial services, but you do have written conditions of release. You're not to possess any weapons. You're not to possess or consume drugs without a valid prescription. With your paperwork, you're going to get an envelope. You need to read the instructions in the envelope, contact pretrial services within 72 hours of your release, and then make sure that you attend all of your future hearings. If you fail to appear at any of them, a warrant would issue for your arrest, and then you'd be held on a bond. Did you have any questions, ma'am?
No.
Please take a step to your left, and the officer will get that for you. Mr. Forger to the podium. Thomas Cadena to the chair. Can I get your name and date of birth?
Covena, and it's, Covena Forger, 12/16/97.
Thank you, sir. It does look like you are here today on 3 cases. You've got 3 warrants that were issued for you. 1 is from Buckeye Municipal Court and 2 are from Goodyear Municipal Court. The first one from Buckeye Municipal Court, this warrant was issued June 18th of 2026. It has an offense date of April 25th of 2026 for 1 count of driving with a license that was suspended, revoked, or canceled. This is a pre-adjudication warrant, meaning you haven't been found guilty of that case. In the Goodyear cases, you have a failure to appear warrant, or excuse me, 2 failure to pay warrants that were issued. 1 was related to a prior DUI. The other one was related to driving with a license that was suspended, revoked, or canceled. Again, it sounds like you failed to pay some fines on those. You're not entitled to court-appointed counsel in these cases, but you could hire an attorney if you would like. I'm going to set a hearing in the Buckeye Municipal Court on August 4th at 2 p.m. and in Goodyear Municipal Court, August 5th at 1 p.m. So they are back-to-back, 2 different locations. Dates, times, and locations will be in your paperwork. Because 2 of them are for Goodyear, you just have the 1 hearing date, and then you have the hearing date for Buckeye. In the Goodyear warrants, they are failure to pay, meaning sometimes you can contact them and resolve that by either paying it off or getting back on a payment plan, but you need to let them know that you have a hearing date, because if you don't let them know and they don't vacate it, they'll still issue a warrant for failing to appear. So if you don't resolve that prior to that, make sure you attend all of your hearings. I am going to release you today on your own recognizance. That is your promise to appear at these hearings, but you do have written conditions. You're not to possess or consume drugs without a valid prescription, and you're not to drive a motor vehicle without a valid driver's license. That'll be in your paperwork, sir. Did you have any questions?
No, thank you.
Thank you. If you step to your left, the officer will get that for you. Thomas to the podium and Edward to the chair. Can I get your name and date of birth?
Thomas Cadena, 07/13/91.
Thank you, sir. You are here today because a direct complaint was filed on June 26th of 2026. A complaint was filed by the state. They allege that you committed the offense of 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony, on the date of March 26th of 2026. I'm appointing an attorney and setting a status conference July 30th at 8:30, a preliminary hearing August 3rd at 8:30. I am going to release you today on your own recognizance. That is your promise to appear at these hearings. You do have written conditions. You're not to possess or consume drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. This will all be in your paperwork. You also must attend all of your hearings. If you fail to appear at any of these hearings, a warrant will issue for your arrest, and then you would be held on a bond. This will be in your paperwork, sir. Did you have any questions?
No.
Okay, so step to your left. The officer will get that for you. Edward to the podium and Angel to the chair. Can I get your name and date of birth?
Edward Wayne Ritchie,
And your date of birth?
6/13/1971.
Thank you, sir. You are here today on 2 cases. You are here today on a new case as well as a failure to pay warrant issued by the Hacienda Justice Court. Your new charge is for 1 count of criminal trespass, a Class 3 misdemeanor. Probable cause has been found. As it relates to your warrant, again, it is for failing to pay some fines for a previous case for disobeying an order of the court. I'm not appointing an attorney to represent you, but you can hire one if you would like. You're going to have a hearing in the Hacienda Justice Court on August 5th at 9 a.m. That applies to both your new case as well as your warrant. So it's the same court, same date. I am going to release you today on your own recognizance. That is your promise to appear at this hearing, but you do have written conditions. You're not to return to the scene of the alleged crime and no contact with any alleged victim, complainant, or witness. That'll be in your paperwork, sir. Did you have any questions?
Hacienda Justice Court, that's in Mecklenburg?
Let's take a look. It is in Surprise.
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 Okay.
Yeah, the location will be on your paperwork, but it does have a Surprise address.
Okay,
All
thank
right.
you.
Thank you, sir. Angel to the podium and Bianca to the chair. Can I get your name and date of birth?
Angel Montalvo, 8406.
Thank you. You are here today on a new case. It is for 1 count of criminal damage and 1 count of disorderly conduct, both misdemeanor charges. I am finding probable cause. I'm not appointing an attorney, but you may hire one if you would like. You're going to have a hearing in the El Mirage Municipal Court on August 4th at 8:30 in the morning.
Dang, on my birthday?
Is that your birthday?
Yeah.
All right. Well, I can't change it,
No, you're
so you can contact them if you want to change it, but unfortunately, for purposes of today, I've got to give you that hearing date. I am going to release you today on your own recognizance. That is your promise to appear. I'm going to caution you to read these release conditions carefully. You do have an alleged victim in this case. You can only have contact with the alleged victim if they consent to that contact. If they don't consent, then no contact during the pendency of this case, okay?
Okay.
Any questions?
No, ma'am.
All right, take a step to your left. The officer will get that for you.
Thanks.
Bianca to the podium and Ivan to the chair. May I get your name and date of birth?
Bianca Duarte, May 28, 2008.
Can you repeat your date of birth?
May 28, 2008.
Thank you. You are here today on a new case. It is for 1 count of DUI, a class 1 misdemeanor, 1 count of DUI with a BAC of .08 or more, a class 1 misdemeanor, and 1 count of reckless driving, a class 2 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have an arraignment hearing in the West Mesa Justice Court on August 4th at 8:30 in the morning. I am going to release you today on your own recognizance. This is your promise to appear at this hearing, but you do have written conditions. You are not to possess or consume any alcohol, and you're not to drive a motor vehicle without a valid driver's license. So all be in your paperwork. Did you have any questions? Please take a step to your left, and the officer will get that for you. Ivan to the podium and Kimberly to the chair. Can I get your name and date of birth?
Ivan Flores, date of birth 01/01/1999.
Thank you, sir. It does look like you are here today on a new case. It is for 1 count of driving with a license that was suspended, revoked, or canceled. This is a misdemeanor charge. I'm not appointing an attorney, but you can hire one if you would like. You're going to have a hearing in the Maryvale Justice Court on August 5th at 11 a.m. I am going to release you today on your own recognizance. That is your promise to appear at this hearing, but you do have written conditions. You're not to possess or consume drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. Since your license is suspended right now, no driving until you get that fixed with the MVD. Questions?
So I got pulled over because my tire was wobbly. I literally just bought the car on Monday, and my aunt just took the registration off of it, and I already have a scheduling to put a breathalyzer in the car for Friday, which is tomorrow, and I barely got my SR22 the week prior, so I'm trying to fix it, but that's my last step to get my license.
Okay.
And I just want to see if maybe if I get that, maybe this could get dropped because I am trying to fix this.
So that's not going to be up to me because this is actually going to take place at the Maryvale Justice Court. So you're going to need to talk to either the prosecutor and or the judge if you want to make that request. But again, that's not going to be heard out of the Superior Court, so I can't grant that request here today.
I got one more question. Is there any way you could grant me, like, so I could drive from my house to work and back home only? Because I live in Mesa and I'm working on Lynchfield and Goodyear. And,
unfortunately, because it is likely suspended under an administrative suspension under the MVD, I don't have the power to grant you that request. It sounds like you maybe have had a previous DUI. I'm not asking you to say anything to that, but based on the SR22, it sounds like you may have had some issues with that prior. So it's likely that your suspension is from the Department of the motor vehicles, and if they are the ones that suspended it, they have administrative power to do that, and I cannot judicially change that for you, which means you will have to take that up with the MVD. It sounds like you were getting close to where you could start driving, but continuing to drive without a driver's license could affect that even longer. So make sure that you do comply with that until you get that corrected with the MVD, okay?
I will, ma'am.
All right, please take a step to your left. The officer will get that for you. Kimberly to the podium, Jillian to the chair.
Right here? Yeah, right there. You're here? Right there. Okay, yes, ma'am.
Can I get your name and date of birth?
Kimberly Nunez, 1231-81.
Thank you, ma'am. You are here today on two cases. You're here today on a direct complaint filed in the Superior Court and a warrant from the West Mesa Justice Court. The warrant that was issued in the Superior Court, a complaint was filed on May 15th of 2026. It has an offense date of April 17th of 2026, and it alleges 2 counts of trafficking stolen property, a Class 2 felony, 3 counts of organized retail theft, a Class 4 felony, 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. As it relates to the warrant that was issued by the West Mesa Justice Court, they have alleged 2 counts of shoplifting, Class 1 misdemeanors. On the case for the Superior Court, I'm going to appoint an attorney to represent you. I'm going to set 2 hearings. These are going to take place in the Superior Court. You're going to have a status conference July 30th at 8:30, a preliminary hearing August 3rd at 8:30. As it relates to the warrant from the West Mesa Justice Court, that hearing is going to be in the West Mesa Justice Court on August 4th. So you do have 3 hearings coming up. One of them is at a separate location, but this will be in your paperwork. I am going to release you today on your own recognizance. This is your promise to appear at these hearings, but you do have written conditions. You're not to return to the scene of any alleged crime, no contact with any alleged victim. You're not to possess or consume drugs without a valid prescription. You also must ensure that you attend all of these hearings. If you fail to appear at any of them, a warrant will issue for your arrest, and then you would be held on a bond. Did you have any questions?
I appeared for the court for the first charges, and there was no charges. So I'm just a little bit, they just, as you're saying, basically, I went there and they didn't charge, and then because they have the right to do so, they have. Is that what you're saying?
Exactly. They've essentially have now moved forward with those charges. And as a result, that warrant issued.
I was just wanting to make sure I was there. Thank you.
And that happens sometimes, and it looks like maybe that's what happened, but they have filed these charges as of May 15th.
Okay. Excellent. Thank you.
All right, take a step to your left. The officer will get that for you.
Okay, thank you.
Thank you.
To my left.
Jillian to the podium. Can I get your name and date of birth?
Jillian Pena, 101488.
Thank you, ma'am. It does look like you are here today on 2 cases. My computer just froze. One moment. All right, it looks like we have a new case as well as a probation case. For your new charges, you're here today for 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of carrying a weapon in the commission of a felony crime, a Class 6 felony. And then because you were on probation at the time of this offense, you're here on a Term 1 probation violation. However, for purposes of today only, I am not finding probable cause. The reason for that is I do not have enough information as to what the alleged substance was. It doesn't mean that these charges are dismissed. It just means I don't have enough information today. They may test the substance and move forward with both of these cases. So although I'm not finding probable cause, I am appointing an attorney to represent you in these cases, and I'm giving you hearing dates. Failure to appear at these hearing dates will still result in warrants being issued for your arrest. You have a probation revocation hearing July 23rd at 8:30, a status conference July 30th at 8:30, and a preliminary hearing August 3rd at 8:30. So again, you're being released as it relates to these, but you must attend these hearings to avoid future failure to appear warrants, okay? Any questions? All right, please take a step to your left. The officer will get that for you. Our remaining cases will proceed as house calls. Our first one is Shayla Vasquez, date of birth July 25th, 1975. This will proceed as a house call due to being a danger to self. She is here today on 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of assault, a Class 1 misdemeanor. For purposes of today's hearing only, I'm not finding probable cause for the dangerous drugs or the drug paraphernalia, but I am finding probable cause for the assault. Although I'm not finding probable cause for the other 2 charges, it does not mean they are dismissed. I am appointing an attorney and setting a status conference July 30th at 8:30 and a preliminary hearing August 3rd at 8:30. I am going to release her to the supervision of pretrial services, but she does have written conditions. She is not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of this will be included in her paperwork. She must also contact pretrial services within 72 hours of her release. Case number 16, Manuel Jaime, date of birth July 1st, 1985. This will proceed as a house call due to being a danger to others. He is here today on 1 count of assault, a class 1 misdemeanor, and 1 count of disorderly conduct, a class 1 misdemeanor. Probable cause has been found. And I'm just going to review something one moment before I continue with this record. I am going to appoint an attorney in this case, and I'm going to set a hearing. This hearing is going to take place in the El Mirage Municipal Court on July 27th at 10 a.m. I am setting a secured appearance bond in the amount of $500. In the event he posts that bond and is released from custody, he does have written conditions. He's not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. If anything changes after I meet with any of these parties, I will update the written record. This does conclude our 8 a.m. calendar, and we will now stand in recess until 11 a.m.
All right.
Okay, good morning, everyone. Please be seated. Thank you. It's gonna take me a minute.
Yeah, but she's coming right now.
All right, while my computer is loading, I'm gonna get started. This is the 11 a.m. initial appearance calendar. For July 16th, 2026, the court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. And prior to calling people to the podium, I'd like to read the victim rights advisement. If you are a victim with a crime pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, dignity, and respect, the right to a speedy trial, the right to be present in court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay. Hey, tell me again, what matter are you here on?
The first two on the calendar, Your Honor. I don't know the numbers, 14 and 15.
Is it 14 and 15? Okay. There's one before that. That's what kind of threw me.
Gotcha.
But,
We have a victim advocate here as well.
And counsel, you're here for numbers. Is it Joseph DeMarco or Nicholas? Both. You're here representing both defendants?
Yes, Nicholas for this proceeding only, Joseph throughout the whole proceeding. He has counsel already. We're just covering both of them.
Okay, so Nicholas, Joseph for this proceeding only, and then Nicholas?
The other way around. Joseph throughout the entirety, Nicholas for just this proceeding.
I don't know if that can. I'm going to express a concern that I have. Well, and then I haven't called it yet, but I don't know if you can represent two defendants in the same matter. I mean,
You can, Judge. As long as the conflict is waived. But they have an undivided interest, same thing as so as long as conflict is waived, we can't have done it several times. We were just here on the same case 3 weeks ago. I did it.
I don't. All right, let me, are you, State, are you ready on these matters?
Yes, sir.
Counsel, you're ready?
Yes, sir.
All right, let's call the first matter, number 14 on the calendar. It is State of Arizona versus Joseph DeMarco. Let's call Mr. DeMarco to the podium. It is. Okay. It is CR 2026-00-7203, and this is defendant 1. All right, I'm going to have appearances, please, starting with the state.
Good morning, Your Honor. Dawn Sauer on behalf of the state.
Good morning, Ms. Sauer. And then I believe there's a victim. There's an attorney here on
Yes.
behalf of the victim.
Good morning, Your Honor. Stephanie Macleister standing in for attorney of record Howard Dorman on behalf of the victim, Luis Ayala Aponte.
And is this going to be as to both matters?
Yes, Your Honor.
Okay. All right. And now for the defense.
Good morning, Your Honor. Quay Smith on behalf of the defendant, Mr. Joseph DeMarco. He is present in custody.
All right. Sir, can I have you give me your full name and date of birth?
Yes, Joseph DeMarco, 04/15/1999.
Okay, thank you very much. All right, we had before I officially called this matter to the, on the record, we had a brief conversation with defense counsel. Defense counsel, I'm not of the position that you can represent both defendants in a, I'm saying this for the record, I'm not of the position that you can defend both defendants in a criminal matter, due to a conflict of interest. Especially, my concern is, there could be a scenario where one co-defendant provides you information that the other co-defendant, who you're also representing, may be a little bit more culpable. I'm not saying this is the case here, but this is just as a scenario. At that point, whose best interest do you represent? The one that said something, the one that's being accused of saying something being said against him or her, and in that case, who would you put on the stand if you were ever to put one of the? You could never put one of the co-defendants on the stand and cross-examine that co-defendant against the interest of another co-defendant. And so with that, I don't believe, and even in that scenario, and I don't know if it's posed here, I don't believe that can happen. And I don't believe, and I've come across it in my journeys in private practice. And I was not allowed to do it. And I believe it is not a waivable right that one co-defendant can have with another. That's the court's position on this. So I know you want to proceed together with the co-defendant in this matter with Nicholas. I know you're going to be, from what we had the conversation before I called this matter officially on record, you're going to be moving forward with Joseph representing him. I guess we could kind of cross that bridge when we get to Nicholas, but just something to be aware of it as the court's concerned. Yes.
Yes, sir, and thank you. And I understand, I don't disagree with the court's analysis regarding, so the example, I should say, that the court put forward about, cross-examination and stuff. And obviously that's clear under the law that, there would be some type of conflict there. However, I have seen it in practice in that situation, and there's a colloquy that the court goes through as far as waiving the conflict in that case, because of the constitutional protections and all that stuff. It is highly unlikely to see it in the trial setting once the stuff moves down the road. This is arraignment court, this is a you just guilty, not guilty, waive formal reading of the charges, release conditions. That's it. It doesn't go any further than that. We don't have any discovery from the state or anything like that. So it's so premature in the proceeding. I do agree with the court's, again, analysis, down the road. And Nicholas does have counsel on the case. He's just not here for this because it's a limited, this is very limited. And so very limited. So if the court wants to consider it, as the big executive standing in for the other attorney. That's right. That happens every day in court where you stand in for someone in a pre-trial hearing. So I'm not sure how the court wants to consider it just for this setting. But moving forward, I would not be, because of the example that the court raised. So
okay. So let's proceed with Mr. Joseph DeMarco here today. And then we'll cross the bridge with Nicholas next. Sir, you are give me if I haven't already done this. So give me your full name and date of birth again.
Joseph DeMarco, 04/15/1999. All
right, sir. You are here today as a result of a grand jury warrant, Maricopa County Superior Court grand jury warrant. And what that means, in case you're unfamiliar, a grand jury was convened on your matter and was presented evidence. That grand jury found probable cause as to 1 count of kidnapping, a class 2 felony, 3 counts of aggravated assault with a deadly weapon or dangerous instrument, all 3 of those counts allegedly as as Class 3 felonies and 1 count of disorderly conduct allegedly as a Class 6 felony, or all 5 counts are alleged, I should say. With that said, I understand that you have retained private counsel. I'm going to let the record reflect that I'm appointing you an attorney anyway. I just want to make sure that at your next court date, which is the arraignment, that someone is there. For some reason, if you move forward with the private counsel that you've retained, that's fine. Counsel, I'm just going to have you file another notice of appearance moving forward after this.
Sure, Doctor. He's mine.
Okay, all right.
It would be Nicholas if you, it depends on when you.
Correct. But you'll see it on the order, just in case something happens, just out of an overabundance of counsel that somebody, caution that somebody's there. But if you file another notice of appearance on or before the arraignment date, you'll just be taken over as you'll just take over as the assigned counsel. Talking about your next court date, it's an original arraignment hearing on July 23rd at 8:30 in the morning in the downtown Superior Court. Next, we're going to talk about your release conditions in this matter. First, I'd like to hear from the state.
Your Honor, the warrant in this case is for $100,000 cash only. The state is asking that the court either affirm that or possibly increase it based on the information that the victim advocate is going to present to the court regarding the extent of the victim's injuries. This was a violent crime, kidnapping, assault with a deadly weapon. There were multiple victims. The primary victim was pistol whipped, punched and kicked on the ground. He sustained a brain bleed and a bullet, I believe, grazed him. He was shot at, multiple lacerations and abrasions. Witnesses who tried to intervene had guns pointed at them by the defendant and the co-defendant. The state believes the $100K cash only is a minimum that should be imposed, possibly increased, but the state does believe that a cash only bond based on these serious charges would be appropriate.
Okay. Thank you. From the victim advocate, please.
Thank you, Your Honor. As the court is aware, when determining the least onerous release conditions, it must consider whether the accused poses a danger to the community and whether the accused is a flight risk. Additionally, pursuant to Rule 39 of the Arizona Rules of Criminal Procedure, the court must also consider the views of the victim. Luis, the victim, respectfully requests the defendants in this case be placed on pretrial services with electronic monitoring if they were able to post a $500,000 cash-only bond for the following reasons. In regards to flight risk, it is well known the defendants in this case are brothers that are originally from New York. These defendants have the means and ability to travel, and it is believed, considering the nature of the allegations against them, they are facing mandatory prison time, giving them all the reason in the world to flee. There's no doubt that these defendants are flight risk. While the defendants may argue they've retained private counsel and likely spent money to retain such private counsel, that merely illustrates their ability to flee. Additionally, simply hiring private counsel does not demonstrate an intent to abide by conditions of release, as we know many people flee despite retaining private counsel when faced with such serious allegations such as these. Quite simply put, if the defendants have the means to post bond, they have the means to travel and the means to flee. While Luis understands the court is compelled to impose the least onerous terms of release, a cash bond in this case helps to ensure the defendant, if they choose to pay such bond, will not risk revocation by contacting Luis or his family or anyone else as a means of attempting to intimidate him. These defendants are violent and dangerous and pose a significant risk of flight. Regarding whether defendants are a danger to the community, the defendant's actions in this case go beyond reason. The defense is likely to assert self-defense as a justification for their actions. However, and without diving too deeply into the facts, the defendant's behavior here is without justification. In order to assert self-defense, the defendants must demonstrate an imminent threat existed. It would defy logic to argue imminency existed when roughly 20 minutes existed between the last interaction between the defendant and the victim, and the defendant's choice to locate the victim as he was attempting to drive away, pursue him, trap him, boxing him in his vehicle with his co-defendant, ordering him out of the vehicle, then beating, kicking, and shooting him in the head. This all occurred over a fight over men's recreation baseball game that ended 20 minutes prior to the shooting. The defendants in this case were so calculated that they were able to hunt someone down, trap them, and eliminate any means of escape, beat him, and shoot him. Luis is a family man. He has children and a wife at home. His oldest child was so scared after hearing what happened, she thought that her father was dead. Luis's children and wife have been in fear of the defendants since they learned what happened to their father and husband, respectively. No child should have to live in that kind of fear. The defendants in this case made a choice. Their choice demonstrates how dangerous, brazen, and reckless they are. While the defendants will likely argue a lack of criminal history, it demonstrates they will still demonstrate that they're a danger to society. Their actions here demonstrate that they are. Their actions here show that they're capable of showing a reckless disregard for the community. There were dozens of individuals in the parking lot where the shooting occurred, with dozens more approaching the parking lot at the time. They have no regard for the safety of the community. Their actions demonstrate an ability and perhaps a desire to kill another human being. To take a husband from his wife, to take father from their children because of a fight on a baseball field. The defendants appear to be at least sociopaths. They are clearly capable of causing harm, if not worse, to others, and therefore a high bond with pretrial services with electronic monitoring must be imposed, if for no other reason than to give the victim, Luis, his wife, and his young children some peace of mind and sense of safety and security. At the end of the day, Your Honor, these defendants attempted to kill Luis. It's that simple, and accountability needs to start here and now.
Okay, thank you. All right, sir.
Yeah, Judge, that's a lot. That's a lot. Let me just say a couple of things. First of all, I want to make sure the record is clear. We'll be filing a motion to disqualify this attorney for the victim's advocate because there's a conflict of interest. From my understanding, she's a coach on one of the baseball teams that's according to this league, and she has an axe to grind. In fact, to the extent that she started a GoFundMe page for the alleged victim, and I mean, there's a whole about all of this stuff. There's a clear conflict here. What is clear here is the law, one, and two, the facts leading up to this hearing today. Number one, the law does not suggest that the court gives the least onerous conditions. It mandates the court to do so. The law says, Gusick and Costa and the cases subsequent to that the bail is constitutionally excessive. It is set at an amount greater than necessary to achieve its authorized purpose. The authorized purposes of setting a bail is to ensure that the person appears at court proceedings and to protect from intimidation of witnesses, and the court must set the least onerous amount. That's not up for suggestion or advice. That's well settled law in the state of Arizona. Here's what's important, I think, to this proceeding today. Number one, just 3 weeks ago, we were here, okay, with these same two young gentlemen, well, this defendant and the co-defendant in the matter. The facts of this case, sir, has not changed at all. The victim is actually in a better condition now than he was when we were here 3 weeks ago. He's out of the hospital. He's reunited with his family. There's some things that were said by the victim's advocate, which this ain't the trial. We're not here to argue the facts. These fellas, this one, he has the presumption of innocence under the Constitution of the United States and of this state. With that being said, we're not here to argue the facts of the case. It's not a matter if they allege self-defense. They have alleged self-defense, and those matters are left to the trial court. For today, for release purposes, we were here 3 weeks ago. This court, the same court, set a $50,000 bond. That bond was appropriate. The facts have not changed. In fact, normally we wouldn't even be in here, Judge. This would have been, if the police would have handled the process, and I'm not faulting the police, but if the police would have filed paperwork in a timely manner or whatnot, this would have normally been a grand jury summons. We would have been over at downtown court. They would have told them what the charges would have been on the way. For whatever reason, they, came out in the style of a warrant. From the 3 weeks ago when we were here, Judge, when the $50,000 bond, secured appearance bond was set, these fellas have obeyed every law. They have completely cooperated with the police. For example, under the previous case, they said, hey, we need DNA, we need testing. We went down there. We gave them the DNA testing. They got a warrant, Judge, to search the phone so they can see what was going on. We didn't require them to send the phone to the FBI lab or nothing. We gave them the passwords to the phones. Go in and get the information. When we got the warrant yesterday about this warrant, the police didn't have to come kick down any doors or any of that stuff. We went down to the police station. These fellows turned themselves in. They've been sitting in jail overnight. They haven't had any electronic monitors. They have not. There is no record of them trying to contact the victim, and they're not. They want to defend this case in court. So based on the law, to secure their appearance, cooperate with the proceeding, that's exactly what they've done under the bond that's already in place which is the $50,000 bond that's still in place. I guess it would need to be moved over to this case that's already in case. $100,000 cash bond, and then the victim advocate. That's laughable. I hate to say it so strong, but that's laughable. $500,000 cash bond. I represent people in this court that's convicted of first-degree murder and murder that don't have that high bond. They got $100,000 secure bond. To do that, it's clear that she has an axe to grind. And so, again, this is what has happened since then. Our request is that there's been a bond in place. This court put it in place. Not this judicial officer, but this court put it in place. $50,000 secured appearance bond. Let these fellows keep doing what they've been doing. They accurately point out there is no criminal history. There is zero criminal history for these fellows. There's a series of things that the court must look to. They have to consider the views of the victim. The victim has been hurt, but the court is not bound by that. And I think on its face, setting that paramount, that makes it right for appeal, special action, because it's outside of what the Constitution would allow. These men are not of excessive means. In fact, this particular defendant is, once this gets to the district or to the court downtown, an indigency actor. He doesn't have that. He's a bar, worked at a bar, you know, at the front. He doesn't have that kind of money or whatnot. And so, again, what is being requested by the state and by the victim is exactly what is prohibited under Gusick and under its protege cases, you know, Costa versus Mackey, and this cash only $100,000. That's excessive. The court has to impose the most least onerous, I should say. And again, some of this stuff, he was shot. He was not shot. That's not what happened. That's not what happened. He was shot. That's not what happened. And that's not left for this court. That's left for the trial of fact court. Here, there's been a bond in place for the last 3 weeks. These young men, this in particular, has complied with them to make that excessive jump on the same facts, and nothing has changed. I think would be invidious of what the Constitution requires. So again, my request is that there's a bond that's been in place. They've been abided by. They've been cooperating. They've been showing up. There's no history of failure to appear. It's because there is no criminal history, intent to kill other people and all of that stuff. I'm not going to address that stuff. They have an axe to grind. So,
Counsel, was the bond posted?
Yes, sir. Absolutely.
I don't see anything.
It was on the previous case number. If you want the previous case numbers, it might be on your PS filing, so I'm not even sure if it's in the system. But it would need to be moved. The bail department is still in place, and they'll transfer it over to this. It was $50,000 secured appearance bond, and it's worked. And they showed up when they cooperated. And the previous case numbers, the court wants it. For this particular, they had them on the 2 case numbers previously. It's CR, well, it might be PS in your system, 2026 124538-001. And I'm not sure if they've changed in the county jail system, but it was posted. $50,000 for each of them was posted previously 3 weeks ago for the same thing, same facts.
Your Honor, obviously since then, excuse me, there was a grand jury indictment. The grand jury felt the cash bond was appropriate after hearing evidence, which was more extensive than what is being presented to the court today.
Counsel, for the state, that's what I wanted the discern is so there was a there was a bond posted, and then the matter went to grand jury after that fact.
I believe so.
Okay.
Yeah, Judge Matt, yeah, that's correct. But again, that's in the court. That's standard proceeding, whether you go to preliminary hearing or grand jury. The only reason why we're here is because whatever paperwork from the law enforcement agency wasn't filed on time, and it went to warrant instead of summons. That's the facts of this case are the same. Nothing has changed.
Your Honor, since the initial case that had the $50,000 bond, that case is no longer active. The current case, they added kidnapping charges, and that's the one that went to the grand jury and got the cash bond.
And that's just the way they're charging the case. I'm not talking, they can charge the case however they want to, and you can indict a ham sandwich. The facts of this case have not changed. And, well, I think the judge, and you look at the case.
Well, when the court said bond release conditions for the $50,000, they're only setting it on the charges, and kidnapping was not one of the charges on the case.
So counsel for both. All right, I think I've gotten the gist. I think, all right. So based on the argument of both counsel, taking everything into consideration, including the victim's statement through the victim's attorney, I do believe that there is, there could be a variation of what was heard by the initial appearance judge 2-3 weeks ago, versus the evidence fully presented to the grand jury later, after the fact. Obviously, I don't have all of that information of what the grand jury saw in terms of how they made their determination as to that $100,000 cash-only bond. The increase in the increase in charges could have led to that, or maybe there were factors that may not have been in the initial report, or may have been included in a supplemental report as well, that could have been presented to the grand jury as evidence. Excuse me. In either case, they found probable cause as to all the counts, and they were privy to information that I'm getting firsthand here today. That they were privy to more detailed information than that. Given the nature of the offense, and it wasn't like he went from an aggravated assault and, you know, they added a few, well, there was some simple drug possession because he was caught with 2 or 3 pills of something silly, not to take away from a charge like that. But if it was kidnapping that was ordered as well, or charged as well, that's a severe addition to the offense, to the overall allegation. With that, I am going to order that the grand jury bond, a cash-only bond of $100,000, be affirmed, and I am going to also include that if that bond is posted, that the defendant be equipped with an electronic monitoring device, also known as an ankle bracelet, prior to his release from custody. There are other release conditions that the defendant must also abide by. I'm not going to go over all of those here today. They involve not going back to the scene of the alleged crime or having any contact with the alleged victim or witnesses in this matter, and you may not have any contact with the co-defendant in this matter as well. The rest of your release conditions, I'm not going to go over with you here today. They're going to be included in the paperwork that you're about to receive. All right, if I can get I don't know if counsel, you've been given a copy, but if I can get a copy to counsel of that paperwork, I'd appreciate it. Anything else from the state?
No, Your Honor. Thank you.
From the victim?
No, Your Honor. Thank you.
From defense?
Just one second. And just want to clear over.
Thank you.
You are like a cash only bond.
That's right. Not secured appearance. An affirmation of the grand jury's decision. All right, with that,
I want to make an offer of proof on the record, but if I think it's excessive and will be found unnecessary, I think it's excessive, way excessive. And so, of course, willing to hear an offer of proof, we'll file, but I just want to make sure that the record is clear about that.
okay. All right. With that said, sir, you're going to get a copy of all your paperwork. I believe counsel's been provided with everything as well. If I can have you step to your left.
Judge, you want me to put the offer of proof on the record or just put it in writing pursuant to 103?
We wouldn't be, you could put it on the record now. I mean, but here's the thing. I think it might be better suited down the road. My guess is, I'm not telling you what to do. I can't give legal advice. My guess is that this is probably going to be re-argued downstream. So I think that would be better suited with the court of record downstream.
Okay, I just want to, of course, you kind of put it on the record first, because I think it's a fundamental error. Sure. And also, I just want to make sure that it's noted that I don't know if you're going to hear the motion to exclude victim counsel.
I won't be.
I just want the record to be clear.
Can I,
You folks, and I don't, and his argument about the, I focused on what the facts of the case are, more so than, any conflict with victims counsel or representative at this point as well. So, who could literally, from my understanding, could literally be anyone, not an attorney, a family member, on and on and on. So, with that said, sir, if I can have you step to your left.
Thank you, Your Honor.
If we can have Nicholas DeMarco come to the podium as well. All right, sir. Let me call this. This is State of Arizona versus Nicholas DeMarco, CR 2026-007203, and you are currently listed as defendant number 2. If I can have appearances from the state.
Dawn Sauer on behalf of the state, Your Honor.
Thank you very much, Ms. Sauer, from the victim movement.
Stephanie McLeaser in for attorney Howard Dorman on behalf of the victim, Luis Ayala Ponte.
Thank you. All right, and again, I'm gonna, for defense counsel, I'm gonna reiterate my same concerns about representing the same defendants in a criminal matter. I understand that there may be another counsel that is going to be representing Mr. Nicholas DeMarco moving forward.
Yes, Your Honor.
Counsel. And you're here just
on behalf of Mr. DeMarco. Yes, he already has counsel retained for him. Was unavailable for these proceedings. So,
again, I'm gonna reiterate my concerns. Again, if Mr. Nicholas DeMarco provided you with any information in confidence about the case that could be adverse to his brother Joseph DeMarco, that could be a conflict of interest matter all the way around. So, with that said, I'm gonna. And my concern is that you may be conflicted off of the matter entirely with that. And I don't know to the extent that you and Nicholas DeMarco have spoken. If he is represented by counsel, let me just see here. Is it that apparently his counsel was unavailable for the 11 o'clock matter?
one more time, Judge.
Is it that Mr. Nicholas DeMarco's counsel was unavailable for the 11 o'clock matter?
Yes, Judge. He was unavailable. So again, just to be clear, I'm not the case again. It's not uncommon for people to cover other criminal cases, and he has an attorney.
Right, and I believe it is not uncommon for folks that cover other people's cases, but not when they're covering for the same co-defendant in the same case. I'm really concerned that we may be crossing a line here. It's hold on. Is it who's the attorney or the retained attorney for Mr. Nicholas?
Thomas Connolly and Thomas Marlowe.
Or Judge, if you
Sir, were they just not available for the 11 o'clock?
Yeah, they weren't available. That's why.
At all today, or just for 11?
For the 11 o'clock, I believe that they had matters from my understanding. That's why Mr. Smith is here filling in today, just for this matter. Your Honor, I don't know if it makes a difference, me saying this, but I do have counsel. Quasi, Mr. Smith right here is just to cover for this.
I understand, but in covering, then he's taking on that partial representation. And if he wasn't also representing your brother, he could cover or anybody, another co-defendant in this matter. Mr. Smith could cover the entire county for all I care, whatever. But it's the fact that in attempting to represent your best interest, he may also hear things from you that may be in conflict with your brother's case. Or you may say, hey, look, my brother forced me to do it. You know what I mean? And all of a sudden that's an issue. And he can't argue in your best interest while representing your brother's best interest. My thought is, so we don't trip a wire. I'm legitimately concerned with this, and so with counsel even standing in, Mr. Smith just standing in. With that said, I am inclined. Is your attorney available at all?
I don't believe,
even virtually.
I don't know. I would need to speak to them.
Okay. Counsel for the state, I'm inclined to move this to another calendar to have counsel, truly retained counsel for the defendant come in and make the argument. I know that you guys are taking the time to be here today, and Mr. Smith's taking the time. Victims counsel's taking the time, but I just, so we don't trip a conflict of interest wire that starts reversing things down the road about what we did here today. Because of what we did here today, I'm inclined to reschedule this to another not another day.
Your Honor, if I may,
and that's just addressing the court, you're represented by counsel.
Okay.
And I don't want you to say anything that may be against your self-interest.
I understand, but I do have the ability to do so, correct?
May I make a suggestion?
Yeah.
One or two things. This may I suggest.
Yeah.
Here right now, if you're uncomfortable with it, I understand the court's condition. I'm not worried about conflict. Again, I've been in this environment, and I'm sure the court has too. So I'm at least concerned about that. And we don't have anything. The only thing I got is a warrant. That's it. I don't have anything to cover. I don't have anything, and I haven't had.
Right.
Yeah, counsel. So what the court could do if the court's on motion. We just had an argument for the brothers. 9 times out of 10, the court's going to mirror the release conditions for both of them. And so I think the court could, whoever's here for OPDS or whomever else, appoint them to counsel like you would for anybody else that didn't have counsel, let them make the arguments. So since the court has already heard the arguments for one, I'm not sure how the court, you're going with what the grand jury said. And then if counsel wants to make, his attorney wants to make an argument regarding the release conditions, their co-defendants like the argument.
I don't know. Counsel for the state, do you know if anybody's here from Public Defense Services today, other than?
I really don't have any information on where they would be or how long it would take them to get here.
I know they have an office down the hall, but I didn't see the light on this morning. So with that said, I don't want to, sir, I'm going to ask that you reach out and try to contact your attorney, see if he can't appear even virtually, or if not virtually, then even telephonically. And I will allow that in the next calendar, but I think at this point, I don't want to do something here that will then result in a issue.
May I ask why it would result in an issue?
Because if there's a conflict of interest issue, let's say you tell Mr. Smith something that is not potentially, I'm not saying that you did, that you tell Mr. Smith something that would then that would then paint you in a better light and or may paint your brother, a co-defendant, in a worse light. In representing your interest, even if it's just for this hearing only, there's a conflict on, how any attorney would bring that information forward, especially in light, to protect the interest of their other client. So, with that said, I'm going to give you an opportunity. I'm going to go ahead and my apologies for, to all counsel, and I think for everyone for their patience, especially from the state and the victim side, but just so we don't trip a constitutional issue or more so a conflict of interest issue that may give cause to further problems down the road. I'm gonna reset this to the 11 o'clock. To the 2 o'clock calendar, which is in about a little over 2 hours. I'm going to give you hopefully you get a chance to
Appreciate that.
to contact your attorney. Please let him or let them know. I think you have to that they can appear either. I'm granting permission for them to appear either virtually or telephonically. I'm also going to extend that same courtesy to the victim's attorney to appear virtually or telephonically, unless you're just hanging out. But you know, it is a weekday, and I'm sure you've got other things to do. So I believe, Ms. Howard, you're going to be around for the 2 o'clock calendar, or is it somebody else?
We'll be in here all day.
Okay. All right. Then with that said, because of the potential conflict of interest scenario, I am going to move this to the 2 p.m. calendar. I will also, I don't know if I'm going to be handling it. I believe another judicial officer may be handling, but I will also inform that other judicial officer as to what happened here today and my rationale for moving user onto the next calendar, which should take place in about just a little over 2 hours.
Okay.
And I think we're good in terms of time remaining for you to be seen within your 24-hour window. Okay. With that said, I'm gonna go ahead and move number 15 to the 2 o'clock calendar.
Your Honor, I have a question.
Sure.
So while I've been held here, I have not been able to use a phone. In the cell that I'm in, the phone does not work. They have moved me from cell to cell to cell, and it does not work.
Okay, counsel, for the defense, for the other defendant, would you be able to reach out to Mr. Nicholas DeMarco's retained counsel and let them know that I'm allowing, if they could just free up? I'll make sure that they're called at the top of the calendar at 2 o'clock. They're called first, and that they can appear telephonically or virtually.
I guess, Your Honor, short answer, and if I can get the contact information from your JA or your.
Absolutely.
So they know who to call.
Absolutely. And or a link as to how to come in virtually as well. So with that said, I'm going to recall this matter at 2 o'clock. I appreciate everyone's patience. Counsel for the victim, are you going to be appearing virtually or telephonically at that point as well?
Yes, Your Honor.
Okay. Thank you very much. I mean, you can make the statement. Well, no, because that'll be. I was going to say if it was me covering the 2 o'clock, you could make the statement now, and I could, would consider it at that point. But since it's going to be another.
The attorney would need to be there.
Correct as well. So, and it's a different. So, all right. With that, I'm going to move your matter to the 2 o'clock calendar.
Thank you.
And counsel, Mr. Smith, you should be getting new information. That's as long as we start by 2 o'clock. And I'm the impression that as long as we start the calendar at 2 o'clock, which Commissioner Coffin starts on time, maybe even earlier, you should be fine with yours.
Thank you, Your Honor.
You'll be on 2 o'clock calendar?
I will not be. It's Commissioner William Coffin. And it's William, the last name is spelled, sorry, 1 second. CAWTHON.
Oh, Coffin, Commissioner. Okay. Yeah. I couldn't be here.
Oh, I'm sorry if I faded. All right.
Your Honor, quick question. Does the hearing need to start within the 24 hours or complete within 24 hours?
As long as it is part of that calendar at that 2 o'clock, our position is that as long as he's part of that 2 o'clock calendar, even if he's called the last matter on the calendar, as long as it's part of that calendar, it counts for that 24 hours. I will tell the next commissioner I will request that the next commissioner just call this matter first as well. And I think either way would be in within that 24-hour mark.
Okay, understood.
All right.
Thank you.
Thank you.
All right, thank you. And Mr. Smith, I leave it to you to make attempts to contact.
Thank you.
All right. Okay. With that said, sir, if I can have you step to your left, thank you everyone for appearing in person. Yeah, if you want to approach my clerk, she'll give you the information as to how to contact the court.
I'll just send you the link and then.
Thank you very much. Thank you, counsel. All right, with that said, if I can have Richard Savage, please, to the podium.
Good morning, Your Honor.
Good morning, sir. Please give me your full name and date of birth.
It's Richard Kevin Savage, 11/1/1963.
All right, Mr. Savage, thank you. You are here today as a result of two different matters. The first is number 19 on the calendar. It is a new matter stemming from the Maricopa County Superior Court. It is for allegedly 1 count of possession of dangerous drugs and 1 count of possession of narcotic drugs, both as class 4 felony. Excuse me. As to both counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 22nd at 8:30 in the morning, followed by an evidentiary hearing on July 23rd at 1:30 in the afternoon, followed by a preliminary hearing on July 24th. So it's 22nd, 23rd, and 24th of July. That last hearing is going to be at 8:30 in the morning. All matters are going to be in the downtown Superior Court. As to your release conditions in this matter, the court notes the fact that you were also on release for a previous matter in CR 2025-142-769. And not just you, anytime anyone is on felony release for one matter and is alleged to have committed a second matter while on felony release, they are not eligible for bond. With that said, I am going to make that finding that you were on felony release at the time of the commission of this alleged offense.
Yeah, with that, Your Honor, I tried to get in touch with them, and I got a job right away, and I started working from like 8 in the morning till like 5 in the afternoon, and they couldn't give me any classes to go to.
You will have
2-hour classes.
You will have a chance to re-argue the release conditions at your evidentiary hearing on the 23rd. But right now, the fact that you were on felony release,
I'm going to lose my job.
And there's a new matter allegation. You're being held non-bondable.
I'm on.
As to your second matter, number 18 on the calendar.
I just got an apartment and I got a job, and I'm going back on the streets and I'm going to lose my job then.
It's a statute that you be held non-bondable. It's not. It's pursuant to statute. Number 18 on the calendar is your second matter. That's the matter that you were allegedly on release for. It is a bench warrant for the Maricopa County Superior Court for 1 count of possession of dangerous drugs, a class 4 felony, and 1 count of possession of drug paraphernalia as a class 6 felony. I have appointed an attorney to represent you in this matter as well, although I think one may already be appointed. Your next court date is a status conference on July 22nd at 8:30 in the morning in the downtown Superior Court. In this matter, the court has imposed the court is affirming a secured appearance bond in the amount of $1,000. Also, should you be able to post bond in this matter and you are also released on the other matter, there are additional release conditions that apply that I'm not going to go over with you here today, but they're all going to be included in the paperwork you're about to receive. If I can have you step to your left, please. Thank you. Randy Portillo, please, to the podium. Roger Calvis to the chair next to the door. Okay. Yes. Okay, thank you. All right, sir, please give me your full name and date of birth.
Randy James Portillo, 1989, 07/31/1989.
Thank you very much. So you're here today as a result of two different matters. Excuse me. The first matter, number 22 on the calendar, is a out-of-county warrant from the Yavapai County Superior Court for a probation violation. It's in another county, so to the extent possible, I'm gonna order that an attorney be appointed to you at the next hearing, but I'm sure that's something that they're gonna take care of in Yavapai County. Your next court date on this matter, on the out-of-county matter, is an arraignment on July 21st at 8:30 in the morning in the downtown Superior Court. As to your release conditions in this matter, the court is affirming this court is affirming the Yavapai County Superior Court's bond request of a secured appearance bond in the amount of $25,000. Should you be able to post that bond, there are additional release conditions that apply. I'm not going to go over those with you here today, but they're going to be included in the paperwork you're about to receive. As to your second matter, number 21 on the calendar, it's a new matter stemming from the from the Maricopa County Superior Court for one count, allegedly, of possession of narcotic drugs for personal use as a class 4 felony. The court has found probable cause to exist as to that count. Your next court date is a status conference on July 22nd, followed by a preliminary hearing on July 24th, both at 8:30 in the morning, both in the downtown Superior Court. I have appointed an attorney to represent you, and your release conditions in this matter include a placeholder bond in the amount of $50. So I just put that bond in place so then you could start. I don't know if you're going to be able to post bond in that other matter, but if you are not, I put a bond in place on this matter so at least you start earning credit for the time that you're serving while in custody. Again, should you be able to post bond in both matters, there are additional release conditions that apply that I'm not going to go over with you here today. But both of them include the fact that you contact your probation officer within 72 hours of your release. The rest of your release conditions as to both matters are going to be provided to you in writing here momentarily. If I can have you step to your left, please. Roger Calvis, please, to the podium. Morning, sir. Please give me your full name and date of birth.
Roger Donald Kelvis, 10/31/1972.
Thank you very much. Sir, you're here today as a result of a new matter stemming from the Maricopa County Superior Court. It is for, allegedly, one count of aggravated assault against a police officer in an attempt to, or a first responder in the attempt to possess their firearm. One count of recklessly damaging property of a utility company as a class 4 felony. The previous one, the aggravated assault, was a class 3 felony. One count of possession of dangerous drugs, a class 4 felony. One count of shoplifting and one count of resisting arrest, of both as class 1 misdemeanors. As to all counts, the court does find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 22nd, followed by a preliminary hearing on July 24th, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions, the court has noted that you have 11 prior felony convictions in multiple states. In addition, the allegations against you include multiple dates of offense as to at least the theft in question. The fact that you are alleged to have attempted to grab or did grab the officer's rifle.
Sorry.
And that's of concern both to the safety and all of the allegations are a concern to the safety to the community. But that one, along with your priors, is really of concern to the court.
That is a fabricated charge. I never did any such thing. And when the body cam comes out, you'll see that I'm telling you the truth. I'm not a violent person, and I would definitely never try to assault a police officer.
And the allegation is also, and I'm not arguing with you, but the allegation is also that it took 4 officers to take you into custody. With that said, the court is imposing a secured appearance bond in your matter in the amount of $50,000. Should you be able to post that bond, I'm also going to order that you be outfitted with an electronic monitoring device, also known as an ankle bracelet, prior to your release. The rest of your release conditions I'm not going to go over with you here today, but they're all going to be included in the paperwork you're about to receive. If I can have you step to your left, please.
I think that's, kind of,
Given the number of historical felony priors that you have and the multiple dates of alleged offense in this matter, the court is going to be affirming its decision.
okay, a lot of that is.
At this point, if I. Go ahead, but please keep in mind that anything that you're saying is being recorded, and I'd hate for you to say something against your self-interest that could be used against you down the road. I have appointed an attorney to represent you. You're going to be meeting with him or her in the next couple of days or so. You can address your concerns about your case and your release conditions with that.
And where do I should pay my bail at the bond? Just go to a bondsman company or what?
The officers will also give you a list of bond companies that do accept collect calls from the jail. All right. Thank you very much.
Yeah.
You want to keep
I'm sorry?
you'll need the page 2, yeah, they want to keep it up again.
Okay. All right, that's fine. We're getting there. Stephen Zamora, please, to the podium. Tyra Scripacci or Scripacci to the chair next to the door. Good evening, good afternoon, sir. Please give me your full name and date of birth.
Steve Zamora, 1585.
Thank you very much. Sir, you're here today as a result of a Maricopa County Superior Court criminal arrest warrant for one count of theft as a Class 3 felony, one count of fraud as a Class 5 felony, and 10 counts of false statements to obtain benefits as all 10 of those. Excuse me, all 10 of those as Class 6 felonies. I have appointed an attorney to represent you in this matter. Your next court date is a preliminary hearing on July 20th at 10:30 in the morning in the downtown Superior Court. With that said, your release conditions, the court is going to be affirming a secured appearance bond in the amount of $1,200, $1,200. Should you be able to post that bond, there are additional release conditions that apply that I'm not going to go over with you here today, but they're going to be included in the paperwork you're about to receive. If I can have you step to your left, please. Okay. Tyra Scapaci or Scapaci, please, to the podium. And Cindy Levitt to the chair next to the door. Good afternoon, ma'am. Please give me your full name and date of birth.
Sarah Angel Scarpasian, November 18, 2003.
Thank you very much. Ma'am, you are here today as a result of 3 different matters. They are numbers 3, 4, and 5 on the calendar. As to all 3 matters, they are all probation violation warrants from the Maricopa County Superior Court. Number 3 on the calendar is for a Class 4 felony. Number 4 on the calendar is for a Class 6 felony. And number 5 on the calendar is also for a Class 6 felony. As to all 3 matters, the court has appointed an attorney to represent you. As to all 3 matters, your next court date is a probation revocation arraignment possible disposition hearing on July 23rd. July 23rd at 8:30 in the morning in the downtown Superior Court. As to all 3 matters, it is alleged that you have violated terms 3, 4, 5, and 15 of your probation. And as to all 3 matters, the court has, and as for each of them, the court has imposed a secured appearance bond in the amount of $750. And that is for all 3 of
for all 3 of them?
For each one of them.
Oh, fuck. All right.
Please keep in mind your length.
Sorry, everyone.
Okay. Now, should you be able to post your bond in all 3 matters, the $750 for each one of your matters, there are additional release conditions that apply that I'm not going to go over with you here today, but they're going to be included in the paperwork that you're about to receive. One release condition that I'd like to point out to you is that you contact your probation officer within 72 hours of your release for all 3 matters.
Okay.
Have you step to your left?
Thank you.
All right, Cindy Levitt to the podium, please, and Robert Fortillo to the chair next to the door. All right, ma'am. Good afternoon. Please give me your full name and date of birth.
Nina Cole Levitt, 042201.
Thank you very much. You are here today as a result of 3 different matters. They are all probation violation warrants from the Maricopa County Superior Court. They are number 7, 8, and 9 on the calendar. They all involve a felony probation violation. As to all 3 matters, I have appointed an attorney to represent you as to all 3 matters. Your next court date is a probation revocation arraignment, possible disposition hearing on July 23rd at 8:30 in the morning in the downtown Superior Court. As to all 3 matters, it is alleged that you have violated terms 3, 4, 7, and 15 of your probation. And as to all 3 matters, and as to each of them, the court has imposed a secured appearance bond in the amount of $250. That comes out to $750 total. Should you be able to post bond in all 3 matters and are released, there are additional release conditions that apply that I'm not going to go over with you here today. But they're all going to be included in the paperwork that you're about to receive. One release condition that I would like to stress to you is that you must, and this applies to all 3 matters, that you must contact your probation officer within 72 hours of your release. I can have you step to your left to collect your paperwork. Robert Portillo to the podium, please. Zachary McVeigh to the chair next to the door. All right, sir, good afternoon. Please give me your full name and date of birth.
Robert Wayne Portillo, 10/30/1983.
All right, sir, you are here today as a result of a justice court warrant from the North Valley Justice Court. It is for 1 count of driving on suspended license as a misdemeanor offense. As to this offense, I have appointed an attorney to represent you. Your next court date is an arraignment hearing on July 21st at 8:30 in the morning in the downtown Superior Court. As to your release conditions in this matter, the court has taken note of the fact that this case, the original date of this case is back in 2021. And the age of the warrant is from 2022. So you've been on warrant status for roughly 4 years. And that's of concern to the court. With that, the court is imposing a secured appearance bond in the amount of $500. Should you be able to post that bond, there are additional release conditions that apply that I'm not going to go over with you here today. But they're going to be included in the paperwork you're about to receive. If I can have you step to your left, please. All right, Zachary McVeigh to the podium, please. And Brian Salbana to the chair next to the door. All right, sir, please give me your full name and date of birth.
Zachary Mark McVeigh, April 13th, 1994.
Thank you very much. Let me just double check something.
I'd like to speak on my behalf, Your Honor.
Sure. I always let folks address the court. I just got to get out a whole bunch of information first. And then you'll be able to address the court if you still need to. So you are here today as a result of 5 different matters. The first matter is a new matter, number 26 on the calendar. It is a new matter stemming from the Maricopa County Superior Court for allegedly 1 count of possession of narcotic drugs and as a class 4 felony and 1 count of drug paraphernalia as a class 6 felony. As to both counts, the court does find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 22nd, followed by a preliminary hearing on July 24th, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court does note the fact that you have a significant number of priors, at minimum 6, and you're on probation for 4 other matters. With that, the court is imposing a secured appearance bond in the amount of $250. Given the nature of the offense here today.
I was hit by a car. I've been going through it. I've had nowhere to go. I've been trying to get into rehabs. This morning I was supposed to be there at the rehab. I got arrested yesterday evening because the cops wanted to be an asshole.
Well, first of all, please.
I'm sorry about the language, but
keep in mind your language to the court, with the court.
I've been going through so much, dude. My language is just going to slip out. You don't understand.
I understand. The other issue is these. Let me just double check something. You know, the fact that you're on probation and, you know, you pick up a new matter while you're on probation.
I've been trying to call my PO. I've been trying to get a hold of her.
All right, let's talk about your probation matters. They are number 23, 24, 25, and 27 on the calendar. They all involve, hold on.
It's all just possession, just little petty possession, you know, all should be waived, Your Honor. Like, honestly,
I commend your efforts to try to get it into rehab. I think that's something that you need to talk to your attorney about, and then also let the probation department know as well. But for numbers 23, 24, 25, and 27 on the calendar, they are all probation violation warrants from the Maricopa County Superior Court. They're all for class 4 felonies, which they are. As to all 4 of your probation matters, I have appointed an attorney to represent you as to all 4 of your matters, probation matters. Your next court date is a probation revocation arraignment possible disposition hearing on July 23rd at 8:30 in the morning in the downtown Superior Court. As to all 4 of your probation matters, it is alleged that you have violated terms 1, 3, and 5 of your probation. And as to all 4 of your probation matters, and as to each of them, the court is imposing a security appearance bond in the amount of $250.
I've never been bonded out. You know who's gonna pay.
Well, all right. So with that said, should you be able to bond out, or your release conditions, or you're able to postpone in some way, there are additional release conditions that apply that I'm not going to go over with you. These apply to all of your probation matters. But one release condition that applies to all 5 of your matters is that you contact your probation officer within 72 hours of your release. If I can have you step to your left to collect a copy of your paperwork, please. Brian Saldana to the podium, please, and Tabari Cole to the chair next to the door. All right, sir, please give me your full name and date of birth.
Brian Saldana, 10/14/1999.
Thank you very much. Sir, you're here today as a result of a new matter stemming from Maricopa County Superior Court. It is for allegedly 1 count of possession of dangerous drugs as a class 4 felony and 1 count of drug paraphernalia as a class 6 felony. As to both counts, the court did not find probable cause to exist. Now, that doesn't mean that your offense is dismissed. It's just based on the information I've been provided so far, I did not find probable cause. With that, I cannot hold you for these offenses, but I will give you a next court date that you have to go to make sure to see what happens with your offenses. With these cases, they may be dismissed, or new evidence may come, or more information may come to light that they will be will cause this matter to move forward. With that said, I am appointing an attorney to represent you. Your next court date is a status conference on July 30th. July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. Again, as I said, as I found no probable cause, I am going to be releasing you here today on your own recognizance. There are additional release conditions that apply. I'm not going to go over those with you. They're going to be included in the paperwork you're about to receive. Just make sure you get to your next court date on July 30th.
Okay.
All right. If I can have you step to the left, please.
Thank you, Your Honor.
Thank you. Tabari Cole, please, to the podium. And Drew Hayward to the chair next to the door.
All right, Cole, now you sit down over there. You sit down over there. Cole, the door in the
All right, sir, good afternoon. Please give me your full name and date of birth.
Tabari Cole, 6581.
Thank you very much. Sir, you're here today as a result of 3 different matters. The first, they are 11, 36, and 37 on the calendar. The first matter is a new matter stemming from the Maricopa County Superior Court. It is for allegedly 1 count of aggravated assault as a class 3 felony, 2 counts of aggravated assault as class 4 felonies, 1 count of assault, 1 count of threatening and intimidating as class 1 misdemeanors, and 1 count of preventing the alleged victim in this matter from, or interfering with the alleged victim's ability to contact emergency services. That's a Class 2 misdemeanor. As to all counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 22nd. July 22nd at 8:30 in the morning in the downtown Superior Court. Your next court date after that is on July 24th. That's going to be a preliminary hearing, also at 8:30 in the morning, also in the downtown Superior Court. Let's talk about your release conditions next. The court has taken into consideration the fact that you have 4 prior felony convictions, the fact that you are also on probation on 2 separate matters at the time of this alleged offense. And the particular violent nature of the allegations of aggravated assault against the alleged victim. Also that this is a DV matter. With that said, the court is imposing a secured appearance bond in the amount of $75,000. Should you be able to post that bond, I'm also going to order that you be outfitted with an electronic monitoring device, also known as an ankle bracelet, prior to your release. The rest of your release conditions include not contacting the alleged victim or returning to the scene of the alleged crime. You can also not reside in the same location as the alleged victim, and you must find an alternative residence and provide proof of that residence to the court. All right. Let's go to your probation matters next, number 36 and number 37 on the calendar. They are probation violation warrants from the Maricopa County Superior Court, both of them. They are both for, Class 6 felony. In both matters of your probation matter, I have appointed an attorney to represent you. Your next court date in both of your probation matters is a probation revocation arraignment possible disposition hearing on July 23rd, July 23rd at 8:30 in the morning in the downtown Superior Court. As to both of your probation matters, it is alleged that you have violated term 1 of your probation. Term 1 of everyone's probation is not to commit any new offenses while on probation. And the new offense alleged against you is the first matter that we talked about here today. With that said, as to both matters, the court is going to be, and each of them, the court is going to be imposing a secured appearance bond in the amount of $1,500. Should you be able to post your bond in both of these matters and all matters that are additional release conditions that I have not gone over with you here today, they're going to be included in paperwork that you're about to receive. One release condition that applies to all 3 of your matters is the fact that you must contact your probation officer prior to your release. Yes.
So what's going on there? So what, I'm getting a leg monitor or something? Ankle monitor or something? Or what?
As to your first matter, the court has imposed a secured appearance bond, and everything that we talked about here today is also going to be provided to you in writing for all 3 of your case. But the court has imposed a secured appearance bond in the amount of $75,000. Should you be able to post that bond, I'm also ordering an electronic monitoring device, also known as.
Oh yeah, I ain't gonna be able to post it. I mean, cause she got my birth certificate and everything. She got all my stuff, but like I said, I called the police on her. And they documented everything, but they didn't come out. She left, and after that, I'm getting pulled out of bed because they saying I did all this. She got a broken nose. She got all this stuff.
I'd like to let you
know. I ain't do all that, man. I'm not.
I have appointed an attorney to represent you. Just bring this up with your attorney. If I can have you step to your left, please.
What's that?
Your paperwork.
Oh, that's it?
That's it.
All right, Drew Hayward to the podium, please, and Timothy Smolnick to the chair next to the door.
Molly.
All right, ma'am, good afternoon. Please give me your full name and date of birth.
Drew Hayward, February 28, 1998.
Thank you very much. Ma'am, you are here today as a result of 2 different matters. The first matter is a new matter stemming from the Maricopa County Superior Court. It is for allegedly 1 count of possession of misconduct involving weapons by a prohibited possessor as a Class 4 felony. 1 count of possession of dangerous drugs as a Class 4 felony. 1 count of carrying a weapon in the commission of a felony as a Class 6 felony. And 1 count of drug paraphernalia as a Class 6 felony. As to D, possession of dangerous drugs, carrying the weapon in the commission of a felony, and the drug paraphernalia charge, the court did not find probable cause to exist. As to the weapons charge, the class 4 felony, the court did find probable cause to exist. With that said, I am appointing an attorney to represent you. Your next court date is a status conference on July 30th at 8:30 in the morning, followed by preliminary hearing on August 3rd at 8:30 in the morning, both in the downtown Superior Court. Given the circumstances in your matter, the totality of your circumstances in your matter, the court finds it appropriate that you be released today on your own recognizance. As to your second matter, number 35 on the calendar, is a probation violation warrant from the Maricopa County Superior Court for a Class 6 felony. I have appointed an attorney to represent you in this matter as well. Your next court date is a probation revocation arraignment, possible disposition hearing on July 23rd. July 23rd at 8:30 in the morning in the downtown Superior Court. As to your release conditions in this matter, I'm also going to be releasing you on your own recognizance. Just make sure you get to your next court date on time. The paperwork of which is going to be provided to you here shortly. Now, there are release conditions, since you are being released, there are release conditions that apply to you on both matters that I haven't gone over, but they're going to be provided to you in writing as well as all my orders. One release condition that I need to stress to you is you're being released. Make sure you contact your probation officer within 72 hours of your release. This applies to both matters. If I can have you step to your left to collect your paperwork. Tiffany Smolnick to the podium, please, and Dempsey Wiles to the chair next to the door. All right, sir, good afternoon. Please give me your full name and date of birth.
Timothy Brian Smolnick, 2/18/87.
Thank you very much. Sir, you are here today as a result of a new matter stemming from the Maricopa County Superior Court. It is for allegedly 1 count of possession of narcotic drugs as a Class 4 felony, 1 count of possession of drug paraphernalia as a Class 6 felony, and 1 count of possession of prescription drugs as a Class 1 misdemeanor. As to all 3 counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 30th, followed by a preliminary hearing on on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release condition, the court is going to be releasing you today, however, to the custody of pretrial services. The pretrial services contact information is going to be provided to you in writing. Make sure you contact them within 72 hours of your release. They're going to monitor you as this case progresses, and they're going to may require certain things of you. Just make sure that you comply with their requirements. The rest of your release conditions, I'm not going to go over with you here today, but they're going to be included in the paperwork you're about to receive. If I can have you step to your left, please. All right, Dempsey Wiles, please, to the podium. Brittany Felter to the chair next to the door. Good afternoon, sir. Please give me your full name and date of birth.
Dempsey Wiles Jr., 4572.
All right. And there's a junior at the end of your name as a suffix?
Huh?
You have a junior at the end of your last name?
Yes.
Okay. I'm going to let the record so reflect that. Sir, you are here today as a result of 2 different matters. The first is number 12 on the calendar. It's a new matter stemming from the Maricopa County Superior Court for allegedly 1 count of shoplifting. As to that count, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd. I keep doing that. August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, given the totality of the circumstances, the court feels appropriate to order you released on your own recognizance here today. As to your second matter, number 13 on the calendar, it is an out-of-county warrant from the Pima County Justice Court, Consolidated Justice Court System. It's for disorderly conduct. as a misdemeanor offense. I don't know if you are eligible for an attorney. I'm gonna ask that an attorney be appointed for you, but that's something that they're gonna take care of in Pima County when you get to court. Your next court date on this matter is an arraignment on July 21st. July 21st at 8:30 in the morning. This is gonna be in Pima County in Tucson. As to release conditions in this matter, given the recency of the warrant issued against you in this matter, I am going to give you a chance to get down to Tucson on your own without the help of the sheriff's deputies here, or the sheriff's deputies from Pima County that would come up and get you and address this matter, and take care of it personally. With that said, I am going to be releasing you on your own recognizance here today. Just make sure you get to court on July 21st down in Tucson. As to both matters, you are being released here today. There are additional release conditions that apply. I'm not going to go over those with you here today, but they're going to be included in the paperwork you're about to receive. If I can have you step to your left, please. Thank you. Yeah. All right, Brittany Felter, please to the podium. Kyle Okai to the chair next to the door.
Hello.
Oh, good afternoon. Please give me your full name and date of birth.
Brittany Ann Felter, 8/12/93.
Thank you very much. Ma'am, you're here today as a result of two different matters, numbers 28 and 29 on the calendar. Number 28 is a new matter stemming from the Maricopa County Superior Court. It is for allegedly one count of possession of dangerous drugs, a class 4 felony, one count of possession of narcotic drugs, a class 4 felony, one count of possession of drug paraphernalia, a class 6 felony, one count of resisting arrest as a class 1 misdemeanor, and one count of obstructing a public thoroughfare, also as a class 1 misdemeanor. As to all counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 30th. July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court notes the fact that you have no prior felony convictions and you have not failed to appear in this or any other court. As such, I'm going to be releasing you today on your own recognizance. There are additional release conditions that apply that I'm not going to go over with you here today, but they're all going to be included in the paperwork you're about to receive. As to your second matter, number 29 on the calendar, it is an arrest warrant from the Maricopa County Superior Court for 2 counts of aggravated DUI as class 4 felony and 1 count of possession of narcotic drugs, also as a class 4 felony. In this matter, I have appointed an attorney to represent you as well. Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court has taken notice that you may not have had what's called actual notice of the fact that this matter was pending. As such, I do not penalize people for not showing up to a court date that they did not know about. So with that said, now you do know that this matter is pending, the Ag DUI matter is pending. You are given the next court date, and I am going to be releasing you on your own recognizance on this matter as well. Again, there are additional release conditions that I have not gone over with you as to this matter, but they're all going to be included as to both matters, along with all my orders in the paperwork you're about to receive. If I can have you step to your left.
Thank you.
Kyle Okai to the podium. Candace Berry to the chair next to the door.
How you doing, Your Honor?
Good afternoon, sir. Please give me your full name and date of birth.
Kyle Thomas Okai, 04/24/91.
Okai. Pronounce your last name again.
Okai, you said it right.
Okai?
Yes, sir.
I did say it right. Okay. Sir, you're here today as a result of just one matter. One matter. It's a new matter stemming from the Maricopa County Superior Court for 1 count of possession of misconduct involving weapons as a prohibited possessor as a class 4 felony, and 1 count of theft as a class 6 felony. Give me 1 second. Okay. I mean, I don't. As to both counts, I'll get to that. I'll get to your release conditions here in a second. As to both counts, the court did find probable cause to exist. Your next court date is, I have appointed an attorney to represent you. Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions, the state is indicating that you have priors. However, in the criminal history that I'm seeing, I don't see any priors. I'm not asking you to comment either way, but given on the information that I have on the criminal history side, I'm going to note the fact that, I don't see any priors or any FTAs in this or any other matter. So with that said, I am going to be releasing you on your own recognizance here today. There are additional release conditions that apply that I'm not going to go over with you, but they're going to be included in the paperwork you're about to receive. Just make sure you get to your next court date on time. All right, with that said, if I can have you step to your left, please. Thank you. Candace Berry, please, to the podium. Arthur Elm to the chair next to the door. Good afternoon, ma'am. Please give me your full name and date of birth.
Good afternoon, Your Honor. My name is Candace Berry, birthday June 14th, 1983.
Thank you very much. You are here today, ma'am, as a result of a new matter stemming from the Maricopa County Superior Court. It is for allegedly one count of unlawful use of means of transportation as a Class 5 felony. As to this matter, as to this count, the court did find probable cause to exist. I have appointed an attorney to represent you.
Thank you.
Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court notes the fact that you have no felony priors or no failure to appear in the court. So with that said, I am going to be releasing you on your own recognizance here today. There are certain release conditions that also apply. You can't have any contact with the alleged victim or victims in this matter, or any complainants or witnesses in this matter, that kind of thing. The rest of your release conditions, I'm not going to go over with you, but they're all going to be included in the paperwork that you're about to receive. If I can have you step to your left.
Thank you so much.
Arthur Elm, please, and Adam to the podium, and Adam Cerna to the chair next to the door. All right, sir, good afternoon. Please give me your full name and date of birth.
Arthur Elm, 9/30/81.
And is there the fourth after your?
Correct. Yes.
All right, thank you very much. Sir, you are here today as a result of a new matter stemming from the Maricopa County Superior Court. It is for allegedly one count of possession of narcotic drugs for sale, one count of transporting narcotic drugs for sale. Both of those counts are Class 2 felonies. One count of possession of dangerous drugs for sale as a Class 2 felony as well, and one count of possession of a firearm in the commission of a drug offense. That's going to be a Class 4 felony. As to all counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. Given the nature of the offense and the totality of the circumstances surrounding it, plus the fact that you have no priors or failure to appear in this matter or in this or any other court, I am going to be releasing you on your own recognizance here today. There are additional release conditions that apply. One of which may be a bit onerous for you, but it is my order. You cannot go back to the scene of the crime. I understand of the alleged crime. I understand that may be your place of residence, but you cannot go back there because it is the scene of the alleged crime. And that's going to be in full force and effect until another judicial officer changes that or until the conclusion of your case. Again, I've appointed an attorney to represent you, so you can bring that up with your attorney. Given the fact that I am not allowing you to return to the scene of the alleged crime, I am giving you one civil standby order. And what that is that you contact local law enforcement in the city or town that you live in, wait for them to show up at your current residence, and under their supervision and control, you will be allowed to take out certain essential items from that residence and then move them to your alternative residence. And I'm also ordering that you Oh, I have to reprint this.
How long does that take place?
Again, give me one. It's not going with that. I am also gonna order that you find an alternative residence. Again, these orders are gonna be in effect until either the conclusion of your case or until another judicial officer changes them. Again, since I have provided you with an attorney to represent you in the matter, when you meet with your attorney, please address these release conditions with him or her, and they could bring that up as an issue to future courts.
Okay, that's a lot of information. Okay.
It's also gonna all be provided to you in writing. I did re-sign it. We are gonna be reprinting that. All right, if I can have you step to your left and your paperwork will catch up with you. Adam Cerna, please, to the podium. And if I can have Titus Gully to the chair next to the door. All right, sir, please give me your full name and date of birth.
Adam Cerna,
And your date of birth.
7988.
Sorry, my computer is reloading for some reason here. Okay. 7988. All right, sir, you are here today as a result of two different matters. The first matter, number 34 on the calendar, is a new matter from the Maricopa County, stemming from the Maricopa County Superior Court. It is for allegedly one count, possession of misconduct involving weapons, of possession by prohibited possessor as a class 4 felony, one count of possession of dangerous drugs as a class 4 felony, one count of carrying a weapon in the commission of a felony is a class 6 felony, and one count of possession of drug paraphernalia also is a class 6 felony. As to all four of your counts, the court did not find probable cause to exist. Therefore, it cannot hold you on this offense. Now, that doesn't mean that your case is dismissed. That just means based on the information I've been given so far, I didn't find probable cause to exist as to these allegations against you. I am going to give you a future court date. Make sure you go to that court date and you'll find out whether or not the case is dismissed or additional information has surfaced that will enable it to move forward. Just make sure you get there. With that said, I have appointed an attorney to represent you. Your next court date is a status conference on July 30th, followed by a preliminary hearing on August 3rd, both at 8:30 in the morning, both in the downtown Superior Court. Again, there's no PC on this matter, so as to this matter, I am releasing you on your own recognizance. Your second matter, excuse me, second matter, number 38 on the calendar, is a probation violation warrant from the Maricopa County Superior Court for a class 4 felony. I've appointed an attorney to represent you in this matter as well. Your next court date is probation revocation arraignment, possible disposition hearing on July 23rd. July 23rd at 8:30 in the morning in the downtown Superior Court. It is alleged that you have violated term 1 of your probation. Term 1 on yours and everybody else's probation is not to commit new offenses while on probation. Now, I didn't find probable causes to that other alleged offense. So with that said, that doesn't mean your probation revocation matter is just completely dismissed. You're just going to have to go to the next court date to find out. But I am going to be releasing you on your own recognizance in this matter as well. As to both matters, there are release conditions that apply that I haven't gone over with you. They're going to be included in the paperwork you're about to receive. But one of the things that applies to both matters is that you contact your probation officer within 72 hours of your release.
Yes, sir.
All right?
Yes, sir.
With that said, if I can have you step to your left to collect your paper.
Thank you.
Thank you. All right, Titus Gully, please to the podium. Okay. Good afternoon, sir. Please give me your full name and date of birth.
Titus Gully, 3/19/1982.
1982. Thank you very much. Give me one moment on your matter, please. All right, sir, you are here today as a result of a new matter stemming from the White Tank Justice Court. It is for allegedly one count of assault as a Class 3 misdemeanor. As to this offense, the court did find probable cause to exist. I am appointing an attorney to represent you. Are you currently in DOC?
Yeah,
So you have a DOC hold?
yeah.
No.
Well, no.
There's no DOC hold?
No.
Employee.
It was an employee.
Oh, okay, I'm sorry. Okay.
And we've been knowing each other for years. And that, I don't know if she was having a bad day, but I should have read the room that she wasn't in the mood.
All right.
Because we joke like that a lot.
There's, all right. Let me just double check something here. Well, I don't have that information either. So with that said, okay. All right. With that said, I am going to be releasing you here today on your own recognizance. There are certain release conditions that apply. I'm not going to go over all of them with you, but I'm going to go over a few. You can't have any contact with the alleged victim in this matter.
Yeah.
You can't go. I don't know what your employment situation is going to be.
Yeah.
If you're going to continue there or not. I'm going to order that you not return to the scene of the alleged crime. If you are going to be returning there, if you think you're going to be, I can confine that space to just the kitchen of the facility.
There's a place across the street.
But if you're not, I don't know if your employment there is suspended or terminated, given the circumstance that you're in. Right now, it's just not to return to the scene of the alleged crime. All right. So is it separate from the facility that you work at?
Yeah. Well, there's other places you can go. They'll just send you to a different unit.
Okay. All right. Not to return to the scene of the alleged crime. The rest of your release conditions, not to initiate any contact with the arresting officers or any witnesses in this matter. The rest of your release conditions, I'm not going to go over with you here today, but they're all going to be included in the paperwork you're about to receive. If I can, and that you're about to receive, if I can have you step to your left so you can remain in the gallery, but your paperwork is going to catch up with you here shortly. All right. With that said, there are two matters remaining on the calendar, both of which are house calls. The first is number 17, Tabitha Hale. Ms. Hale is here as a result of a new matter stemming from the Surprise Municipal Court for allegedly 2 counts of disorderly conduct, 1 count of assault, and 1 count of criminal damage, all as Class 1 misdemeanors. As to all counts, the court did find probable cause to exist. The court is going to be not appointing an attorney to represent her in the matter in chief, but appointing an attorney to represent her as to the bond issue only. With that said, her next court date is a arraignment hearing on July 21st at 1:30 p.m. in the Surprise Municipal Court, and the court is inclined to impose a secured appearance bond in the amount of $1,500. There are also other release conditions which will apply that will be provided to Ms. Hale in writing at the time of my house call. As to the last matter, Lester Morales, number 2 on the calendar. Mr. Morales is here as a result of a probation violation warrant for a Class 6 felony. I have appointed an attorney to represent him. I will advise him that his next court date is a probation revocation arraignment, possible disposition hearing on July 23rd. July 23rd At 8:30 in the morning in the downtown Superior Court, it is alleged that you have violated by terms 3 and 5 of his probation, and I am inclined to affirm a previously set secured appearance bond in the amount of $750, along with the fact that along with the advisement that should he be able to post that bond, there are additional release conditions that will be provided to him in writing, especially to contact his probation officer within 72 hours of his release. With that said, if after I visit these folks in custody or as part of a house call, if my inclination changes, that inclination change will be reflected in a separate writing, as I will not go back on record on this calendar. With that, we are concluded as the 11 a.m. calendar. Thank you.